ಸ್ಕ್ಯಾನ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ. Just logged into my accounts.
Yes. When do you want? Okay. Right. Friday. Yes. I've seen the draft proceedings. Draft proceedings conducted by the committee after the meeting. Yes. So, what is yes, madam, we'll grant him, let him go through the Minutes of meeting of the high-powered committee. He'll prepare a report and submit it. We'll take it up after 2 weeks, right?
Regarding the objections to IA number,
Huh?
I'll be filing
What
it in the
is-
course of the day, not it is ready.
Huh?
It is ready today.
Objection to what?
IA number one
One of?
of 2021,
Acha.
filed by
Mark the presence, everybody's presence. Ms. Srimati Vani H, learned additional government advocate, submits that objection to IA 1 of 21 shall be filed during the course of the day. Mr. K.
Not may I
learned
see,
amicus.
make a mention, Mala.
Huh?
Let's I one each.
Learned amicus submits that submits that the meeting of the high-powered committee has been held and the draft resolution, draft resolution. Acha, all right. So the action taken report has been supplied to him. However, he prays for and is granted 2 weeks time to enable him to prepare a report and submit the same for perusal of this court. Yes, Mr. Naik. Yes, please, you were saying something.
I 3 of 2021.
Huh.
I 3 of 2021 is filed by me,
Huh.
seeking to implead the intervening applicant in I 1 of 2022.
Huh.
Therefore, it has
I mean-
become unnecessary. Your Lordship may allow IA 1 of 222. I have no
it is
objection.
not even maintainable now.
It is same thing.
She is the
Prayer is
Mr.
same.
Naik,
So
she
your
is
Lordship may
she is filing this learned additional government advocate is filing objections to this IA and they are contesting it. So we will have to pass an order on this,
They-
right? So they are you
let
go
it
through
come
what
next week.
objections they have,
After
right?
they file their
All right.
Very
Just
well.
after 2 weeks. May report. There is one complaint to be made by me. It is ready now. I'll file it in a day or two. I have the complaints ready. I'll file it. Survey report. Yes. So survey report is fine. On the last occasion, on filing of survey report. No, because filed in the open court last time, it was about more than 20, more than 1,000 pages of. So what do you want to do then? No, the last occasion, there was certain direction, that compliance is ready. I'll file it in the day. What direction? Which date? 30th June 2022. 30th June? Yes. Hmm. Hmm. 30th June. Ah. Hmm. We will take it up. Madam, let him file whatever compliance report he files on. We will take it up on Monday, 1st August. Mark everybody's presence. Mr. Monday. Mr. Trinity Learned Counsel for BBMP submits that that directions contained in the order dated 30th/6/2022 have been complied with. He, however, pays for short accommodation to enable him to place the compliance report on record based on 1st of August 20. Huh? Huh. Huh. Okay. So he shall supply shall file a copy of the status report on or before 3rd of August. Learned counsel for petitioners pray for and are granted a week's time to enable them to file objections to the compliance report, if any, list thereof. Don't say third. There's no order listing. Third, he will file. Thereafter, week's time is granted.
A date may be fixed now because compliance is fully done. A date may be fixed now. After that, any date.
So third and then 11th August.
Public.
Yes, madam. Week time.
That's a effect for the.
Kindly 2 days time will be granted. Week time. Week time. How much time? 2 weeks. 2 weeks time you want. 2 weeks. 2 weeks. 2 weeks time. Yes. What office objections, right? So many of them. No, DVT. Early head. What is it? All right, so we'll grant them a week's time, then consider your application. One for the applicant. Let of market presence with RP Sadashivappa, learned counsel for respondent one. Let office objections be complied within 1 week. Is the IA, whatever IA for early head. Is IA 1 of 21 thereof. Yes.
Petitioner.
Huh? What? What is it? Recalling order? Huh? Huh? He is seeking time. We will this thing restore it. Right? Huh?
What is the office objection on this IA?
Hurry, your appeal has been dismissed 3 years ago, and in recalling also time after time. What is that shows the appellant has forgotten about the case. Huh? What person? What is the office objection?
Second says IA to be filed and detailed after.
Detailed affidavit. We are not in a hurry. How much time do you want? Huh? We will grant you 2 weeks. Who is your appeal has been already dismissed. Enjoy. What is there? Why you hurry? 2 weeks time is granted to complete. We are not in a hurry. We just wanted to ascertain whether we can restore, but you have not filed a detailed affidavit. What can be done? Client has forgotten about the case. Yeah. For furnishing PF R1 to R2. And what about current counsel for the appellant undertakes to take out handsome for service of notice to respondents 1 to 3. We don't know. 1 to 3 notice on behalf of respondent number 4 is accepted by learned additional government advocate. Notice is directed to reflect. You said 1 week. You want 2 weeks. All right, 2 weeks. Fine, 2 weeks. Huh? 2 weeks, comply with the but to take steps for service of notice on respondent 9 R9 within bracket capital. Yes. What office objection, right? Who has to comply? 2 weeks time to comply with office.
Next number.
Non-compliance. Weeks time, huh? Huh?
Yes, sir.
Is okay. 11.
Yes.
Next case is okay. So what do we do? Condonation, delay, recalling. So, office objection. Right. 2 weeks time. Then for the appellant, 2 weeks time. Yeah. Be interesting.
I appear for the, hello?
Huh? Huh? Oh, that is 227.
Yes, my lord.
We will take it up after motion hearing cases.
Very well.
We'll take it up, Mr. Rao, after motion hearing.
Very well, my lord.
Yes. Huh? Huh? Hmm. Huh? You are, yeah, who is the, you are appellant, right, madam? So she is.
My lord,
standing in your place.
I am appearing as the appellant, my lord, in the connected matter.
Ah. No, Mr. You are appearing in 13.1.
Please, my lord. I am appearing in the
No.
connected matter, my lord, WA 8 of
He is
2019.
appellant in 13.1.
I am appearing as appellant, my lord. Sajipi John.
Respondent number 10 is dead, my lord. She is the legal heir.
Mr. Vikram, you can talk to her, sort it. What is it? Sort it out. So we are granting her time to comply with office objections.
Applications can be allowed. Already they are served and is appearing.
Huh?
Applications.
IA 1 of 21, 2 of 21, 3 of condonation, delay setting aside amendments of motion, right? Let necessary amended cost type will be filed with the attorney. This there are. So 13.1 says. August. 16th August.
Please.
Litigation. NOC wakalat and all this. This is public interest litigation. We will appoint somebody else as a MICUS. Don't worry. Don't, I mean, it's not your business to file PIL. Don't. What NOC wakalat? Argue this is PIL. You are not getting any relief. So you argue. Why? You tell us what is it. At least you should know what is it about. Mr. Srinidhi, yes, you have to remove encroachment. It has to be done. Who will remove encroachment? BBMP. Where is the encroachment? Good margin area of and so widening. Puram. This by roadside, certain persons have encroached. You have to remove encroachment. Nobody can be allowed to.
Yes.
What? So who
Private-
will remove encroachment?
Private respondent also.
No. It takes care
Yes, no.
of that. Our direction takes
Yesterday
care of
also.
everything. It gives a notice to them. He will address that and then give them this thing a week's time also before implementing. So it's all taken care of.
Yes.
So you tell us who will remove the encroachment. Right. Which office?
Assistant Executive Engineer, Bangalore East.
Assistant Executive Engineer, Bangalore East. This petition, right? Wait, it's being allowed. There is nothing to argue. Nobody can encroach a public road. We are directing removal. You have succeeded. Congratulations on your success. What? The petition is being allowed. You still want to argue. What is it? No, it can't be dismissed. Public interest litigation cannot be dismissed for non-compliance.
It's already referred.
And you cannot withdraw it also, right? Even if private respondents meet you in person and then also you can't withdraw, right? It's being allowed. See, this is what it is. You should always be ready with the case instead of seeking. Senior has become senior. He must have argued thousands of cases like this. What's his name? What's his name? Senior's name. With Mr. So-and-so, counsel for the petitioner. This petition filed as public interest litigation grievance has been made about encroachment on road margin area of 15 meters and 24 meters in survey number 2/5 Agadur village, KR Puram, Hubli, Bangalore East Taluk. Full stop. Instead of examining the grievance for the first time in this proceeding, we deem it appropriate to direct that the aforesaid grievance at the first instance shall be examined by whatever he has just now said. We therefore issue the following direction. Right? Then all blank, whatever name he has told, then jurisdictional police and all that. Right? This is the order. You have got it. So action taken report shall be filed. On or before 10th of October 2022, such a report is not filed. This on 19/10/2022 under the caption directions for passing appropriate.
Actually, kindly to Assistant Executive Engineer Mahadevpura or concerned officer, because we don't know which ward it comes from.
Assistant Engineer Mahadevpura
Or the concerned officer. Or the jurisdictional assistant executive engineer.
or jurisdictional assistant executive engineer, right? Doing an application for extension of time. This matter. I say seeking a password, right? Yeah. There's an order, I go to action the payment, deposit the proceeds of auction before this one. We have, issue tender notification, no one has participated. Again, we are doing notification, including end user also. You are ready, we can, so give it. You sought a password, he is seeking a password. Yes,
Yes.
I'm filing an
For
application.
extension.
What extension we don't know, yes.
Extension of time to auction.
Password. Extension of. Next week, additional government advocate, Mr. Madhukar Deshpande, learned counsel for the petitioner, prays for adjournment to enable a learned additional government advocate to file an application seeking extension of time. Let, for holding an auction, let the petition be listed on next week in Monday. Monday, Tuesday, when it on, first list on 1st of August 2020. Quick objection. Venkatesh Dalwai, Mr. Vijay Kumar Patil, learned counsel for the petitioner, submits that quick objection has been complied with. In view of opposite submission, same is ignored. What is it? Oh, that ambulance. Yes, what happened? Yesterday. You got it, Mr. What is it?
They give only tentative date. This is what we have the track record of this case to indicate that this is how the matter has been pending for 2 years. You also try to see the affidavit. Page 5, page 5.
What, page 3? Oh. All right. So you adhere to these timelines. This has to be done. We'll direct them to adhere to these timelines. By an order passed today, we will direct you adhere to these timelines. Don't postpone it. Mark it. In pursuance of order dated 19/7/2022, the respondents have filed an affidavit in which the tender schedule has been indicated as follows. After hearing learned counsel for the parties and taking into account the fact that the issue involved in this public interest litigation cannot any delay, we direct the respondents to adhere to the timelines which the respondents themselves have indicated in the affidavit filed before this court. Full stop. What would be the time like let the petition be listed for further orders on 25th of October 2022, Mr. Huh?
Yes, sir.
25th. Vacation. 25th is vacation off. 27th October. Huh? What? So you write before that shall adhere to so and so and shall file a further status report with regard to the aforesaid time schedule on or before next date of day. No, with regard to the progress made in respect of invitation of tender in question list on 27th October 2020. Come here, Lordship can't see you. No, no, no. No, this, if you stand here, it gives an idea that you are appearing for an intervener. You are not appearing. Yes, yes. Let a copy of IA 1 of 22 and 2 of 2022 be supplied to learned counsel for respondent number 2. Within 3 days, who praise fund is granted a week's time to enable him to file objection. Yes. Yes, okay. I have filled the statement of objections copy in the order. Looking to then make a submission by a date and. All right, learned mark the presence learned counsel for the petitioner submits that he has received the copy of statement of objection. He prays for adjournment to enable him to go through the same and to argue the matter. This after 1 week, 2 weeks, 2 weeks, 2 weeks.
Well, I am for the complainant, well, pension not given.
No.
Lordship had directed them.
Approval as
9/5/2022 itself we have granted. It is placed before the Lord Finance Department for current.
learned additional government advocate submits that that approval for grant of pension to the petitioner has been accorded on 9/5/2022 and the matter is placed before the finance department for according concurrence. Paragraph in view of purported submission, Learned Counsel for additional government advocate praise fund is granted 2 weeks time to enable her to report compliance of the contained in the order. This immediately after 2 weeks.
My lord, serial number 20, I appear for the complainant, Your Lordship.
Yes.
On the last date of hearing, Your Lordship, this honorable court had directed the accused to execute the transfer deed in the favor of the complainant corporation. If they fail to do so, the honorable court directed the accused to be present before this honorable court, Your Lordship. They have filed an objection to the contempt petition, and office objections are raised on that objections, Your Lordship.
So you have to comply. You said that you will comply with the direction, right? What is the direction? Just a minute. It should be transferred.
The direction is at page number 16, Your Lordship.
So, madam,
Your Lordship,
the revenue records have to be corrected, and after correction of revenue records, they will execute a transfer deed in your favor.
Your Lordship, indeed, they've made a representation to that effect, but from the date of disposal of the writ petition, even until today, they've not made any efforts to get the RTC effected in their favor, and they have written a representation to the Tahsildar as well. That has not been considered yet, Your Lordship.
Madam, sir, they can't be asked to do something which is beyond this thing, right? Beyond their this thing, what they can't do, right? They are doing. He has given this thing undertaking on the last date also that he will comply with the objections. Mr.
Indeed, Your Lordship, but if I may comment.
Madam, you issue, yes. That you should be busy with your mobile in the court. That's what happens. So we are seeking your assistance in this matter. There is a direction, madam. Listen to us. There is a direction by the learned single judge to execute the transfer deed within 4 weeks. Now, what he says that until the his Tahsildar mutates his name in RTC extract, they cannot execute a transfer deed. So they have already filed a representation, whatever. You are not a party to this litigation, right? But we are telling you to this thing, tell him to do it so that they can comply with this order. This has non-compliance has resulted in issuance of bailable warrant. All of them are present before us. So they are willing to execute the transfer deed. But what they say that we can't get the RTC extract mutated until this Tahsildar, you inform him. What? Not objection. Assistant Commissioner, what is the order? Assistant Commissioner. Date. 22/7 has passed an order. What?
22/7/22 is it?
What passed an order? What? No, Tahsildar to do what? To mutate your name. Right? So, madam, ask him to take an action within 2 weeks, and then thereafter, within 2 weeks thereafter, you will execute the sale deed. Right? No hurdles. We don't want to do it in a hurry. You seek instructions. How much time will it take and make a statement? You are not a, please supply her the document. She is not a party, right? You tell her and you make a statement, madam. So, yes, we will take it up on Friday. Friday would be okay. Friday. What? Let her make a statement. Let her make a statement. Yeah, yes. Mark the presence. In compliance of the order dated 28/6/2022, comma, respondents are present before this court. Full stop. Learned counsel for respondent submits that the assistant commissioner by an order dated 22nd July 2022, 19/7/2022, has directed the Tehsildar to mutate the names of respondents in the revenue records. It is further submitted that the respondents have been asked to produce what a it is further submitted that Tehsildar, that the assistant commissioner has asked the Tehsildar to do what? To obtain the records from the survey department and to enter the names of the respondents in the revenue records. It is further submitted that as soon as names of the respondents are mutated in the revenue records, the respondent shall execute a transfer deed in favor of the respondents, in favor of petitioner,
Complainant corporation.
in favor of the Commissioner Tumkur City Corporation. In view of Force's submission, we have requested Srimati Vani H, who is present in the court, to seek instructions from the concerned Assistant Commissioner and Tehsildar, and to make a statement before this court as to within how much time the names of the respondents shall be mutated in the revenue records, right? The presence of respondents for the time being is dispensed with. List on 29 July 2020.
Much obliged, Your Lordship.
Find out, madam. Complied. Complied for non-compliance. Complied on 18/6/2020. Yes. Complied. When, Mr. Please tell us. 20th June. 20. This goes on. 24.
23, I am appearing for the respondent, my lord.
Yes.
My lord, accused is present, my lord.
Present.
My lord, we have executed the
Where
bond.
is
Your lordship has, my lord, the imposed, my lord, issued the, my lord, non-bailable, the bailable warrant at last date of hearing.
What to do?
My lord, we have executed the bond, my lord, before the police, my lord, and yes, he was arrested, and thereafter, my lord, after executing the bond, my lord, he was released.
Fine.
My lord, I have filed the, my lord, complaints affidavit, my lord, he is present before the accused, and my lord, we will file the complaints objections to the complaint contempt, my lord. 1 week time may kindly be granted. 2 weeks time may kindly be granted.
Mark the presence in compliance of the order dated. What is the order? Last date?
Lord, order dated.
Order dated 12/7/2020. The respondent is present before this court. So and so learned counsel appears on behalf of respondent, and praise fund is granted 2 weeks time to enable him to file replies to compliance report. We have granted you 2 weeks time, Mr.
Much obliged, ma'am. Much obliged.
You have been December of the advocate. Yes. Huh? What memo? Contempt. Oh. Who is appearing? Huh? All right. What is it? Not filed. A memo of retirement filed on behalf of so and so is accepted. Office is directed to delete the name of Mr. K. Subba Reddy from because that objections, not objections to compliance report, if any, be filed within 2 weeks. You inform him if he meets you. You inform that we have granted 2 weeks time to file compliance report or objection. Huh? Right. What happened? What complaint? Where is that order?
There is annexure B. At page 36. The portion which is not is not agreed. Policy. Will be maintained until the year 2030 for
Where is that?
page 39.
Where is
It's 39. This amount was used to stay the LIC policy for a period of 21 years.
petitioner states?
Please, he made an investment in favor of a minor child in LIC in the year 2010 in policy bearing child flow. The same would mature when the child is 20 years of age. And the maturity of the same shall not be for the benefit of the child until the child attains 25 years and subsequently the same amount will be transferred in favor of the child through the trust for future prospects and endurance. If the same returns from the LIC policies are less than 1 crore rupees, petitioner shall make use of the difference amount from his personal fund. In case the petitioner is
It's all futuristic, right? It's all futuristic. Please, what do you want to say? That is incorrect statement. No policy. Sir, please tell us which petitioner in this case.
petitioner is the husband.
Husband.
She is in violation of this order. She has foreclosed the LIC policy, has removed 56 units without informing me.
Just with a jointly held, then how she alone could withdraw?
She doesn't demand that. You are
Just a minute. Just a minute.
In both detail and credit paragraphs, I was supposed to be allowed to meet have daily phone calls with her, take her out on weekends, once a year, summer vacations, 15 days. None of this is completely blocked and prevented from.
You find reply.
You'll find a reply. The second part of it is the father has been in the church for almost 1 year, 8 months.
Right. That's the position, right? If compromise decree is not violated, then you file execution. Wait. This has to be heard, right? When will you ask? No. Then you should have gone back to the court and sought a clarification that I want to. You can't do like whatever you feel like. No, therefore you should have gone back to the court saying that whatever you are arguing, you cannot do whatever if you feel like in violation of the this thing, the mutual terms and condition, and say that I am a homemaker and I am whatever. That will not be, Mr. Consequences in law will ensue, right? Whatever if you are violated, you know, this is all not a defense. I am a link. Why did you agree for this? Please be ready. Consequences will ensue. Better to come with a proposal which is acceptable to both the parties. But otherwise, we will have to proceed. I mean, this is prima facie a violation. Not a question of receiving any money, Mr. This is not a new case you are arguing. This is not an appeal from this order. You are not. It's not that we will grant you your wishes in this contempt. The question is what punishment should be imposed on you for violating. You are not. You have withdrawn this amount. How? How can you withdraw in the face of this? No, petitioner is that petitioner is who, Mr. She is the petitioner. No, it's that order which he has. Then you have purchased. Who have purchased, right? He has not withdrawn. You said I have purchased this. No, what is this? This is what. So do you understand what is mentioned at page 39? So how can you withdraw the amount in your name, anybody's name, Mr. Patil's name? How can you withdraw? No, be ready then. Tell us how much. We will hear you on sentence then. If the violation is admitted, right? You have admitted. Then so this is in violation of the whatever you agreed before the court, right? No, housewife unfortunately does not have a license to violate the orders of the court. Nobody, including housewife, single parent, nobody has any right to violate the order. We are also bound by, so long as we occupy this chair, we are also bound to maintain the dignity of the court. We cannot afford to act anything and say anything we feel like sitting on the chair. So everybody is bound. So you tell us how, what are the citations? We will hear you on punishment quantum. How much sentence should be imposed? Then be ready. Because violation is admitted. And this all is no defense. That I am a housewife is no defense. Please show us in contempt what is like. So what is a valid defense to contempt proceeding? Please study. Right? Oh, you are so confident. What is it? Advise your client properly, Mr. Otherwise, she will land in trouble. Nothing will happen to you. You are here. You are an officer of the court. You will enjoy. Your client will have problem. Don't be in a zeal to argue the matter. Don't do something which will eventually harm your client. Right? You understand what is the legal position. You are admitting that you have violated the order. Now the question is only of quantum of punishment. Fine. Not on record. What is not on record? So you have. So that's why we are telling you that you are not disputing the order. You are not disputing that you have violated. So now tell us. You should tell us, an officer of the court, what should be the quantum of sentence in such a case. Fine. How much fine and for how much period she should be sent somewhere. So you should tell us on that day. No, what does it mean? Single care taking together. So therefore she can flout the order. Then what is So you understand, right? How
Yeah,
many years of practice with the council?
Yeah, we have received the tablet.
If you have some difficulty, we can appoint a amicus for your client because we have been doing this. Young councils, how many years? 12, 23. You understand, right? What is getting back? So we only hope that you will advise your client properly about this. Or if you want, we will, this thing, we really don't want to proceed, it's a matrimonial dispute. But because of your stand and the showing, we will have to take an action against her. She doesn't realize that what her counsel is arguing here. What is getting back? Violation of the court is admitted. Give her a proper advice to purge the contempt, or we will have to appoint some senior counsel to assist her in case you are unable to render assistance to her. We don't know what you should do. Don't precipitate. It's not this thing. Find out a solution. Advise, Mister. It's not. You are on the wrong footing. Advise your client properly to settle the matter. Understand? We otherwise, if you ask upon to us to adjudicate, we may have very limited options. We can't bail you out, right? That's your misconceived notion that single mother can do anything. So you tomorrow you will say that she has committed theft. Single mother, no option. So she should not be punished, right? She should not be punished. Single mother taking care of child. It's not. It's not a defense under contempt of court, sir. Is it a defense under contempt? No. Then what will happen? You should think about it. Don't be in a zeal to contest and argue anything which will land your client in trouble. That's the advice. Otherwise, you are free to argue. This petition has been filed for non-compliance. The order dated 12/12/2019, passed by Principal Judge, Family Court, Bangalore. The council for the parties submit that the pleadings are complete. Let the same be listed for hearing on 8th of August 2020. The Red Council for Respondent praise fund is granted a week's time to enable him to comply with office objections. List on which date? 2nd August 2020. Why? So what is this? You have filed a statement of objection. It's being adjourned at your instance for such a week's time. That we may not be. Right. 8th August. So, Mr. Now, any cases we have fixed the date on 8th August. Yes. Next date you should tell. Yes. Tell us. You keep on saying anything. That day there will be 100 matters.
Ask you for the complaint.
Yes. Right. Yes.
We inform that I received the
Complied. Yes. Which endorsement has been issued on 15/7/2022. Accordingly, petition is disposed of. You want the liberty? It's against you. With liberty to challenge the endorsement. Yes. for that another round, right? Huh? No, you challenge it, whatever. No, where is? Huh? What is the direction? Huh? That's all right. What is the, which page? No, there's no direction at page 12. Page 12 is cost right. Page 30. All right. Order termination is relieving our quest, so no compliance shall be deemed to have continued with service benefits. So there is no quantification of amount. You are saying you are not, it has not been, they have given you service benefits. How much? Where? 19 lakhs. So that is not sufficient according to you. You are entitled to 60 lakhs, right? This is your case. We can't compute in a contempt petition what should be the amount of this thing service benefits. Please understand. But how do we compute in a contempt? See, please, the predicament is we understand that you will be sent to another round of litigation. We understand. But the problem is that in a contempt, if we want to punish them, we have to hold that there is a willful disobedience. Supposing if they say that according to us, the service benefits are 19 lakhs 15,258. How do we hold that it is 60 lakhs 50,428? How do we hold and then punish them and send them to jail? How that can be done in a contempt? There is no element of willful disobedience. Please appreciate this. No. Review petition, any amount is quantified, you tell us. We will ask them to pay them. That's what we are telling you. When have you paid the amount? That's it. Anything else? No, this is not a writ petition. This is a contempt petition. We have to decide whether or not there is an element. We have told you. We have got it. They will disappear. You are retired. It's all understandable. But law remains the same. Will you disappear, Mr.? Huh? Huh? Yeah, very much here. He says very much here. We don't know. We don't know. We can't go into all this. There's no order. There's nothing. All this is what the problem is. You read what direction according to you has not been complied with. Where does it say back wages, all this much amount on account of the order should have said this much out account to back wages, this much amount gratuity, whatever. Uh, 54. Yes.
Directed to release the retirement benefits, that's all.
No amount. We can't infer an element of willful disobedience. They have complied with this. That's the problem. What to do? This petition has been filed for non-compliance of direction contained in the order dated 11th of November 2016. Paragraph. Learned counsel for the respondent submits that in compliance of the aforesaid order, between a period from 30th for 2013 for
Non-compliance of
this petition has been filed for non-compliance of the order dated so and so 11th of December, 11th of November 2016, passed in WP number 2474/2012, WA number 64/2017, dated 24/7/2019, and RP number 485/2019, dated 25/2/2022. Learned counsel for respondent submits that in compliance of the aforesaid direction, an amount of rupees
20,15,000.
19 lakhs 15,000 458 has been paid to the appellant on account of service benefits between a period from 30th April 2022 to 13th April 2022 to 3rd of June 2022. Paragraph. However, the aforesaid statement of fact is disputed by learned counsel for the petitioner. Learned counsel for the petitioner submits that the petitioner is a retired employee and respondent shall. What respondent? What did you say? Respondent shall? You said something about respondent, right? And BEML shall, Messrs. BEML Limited shall disappear. Then what did you say? Disintegrate. Acha, and shall be Messrs. So and so. BEML Limited shall undergo a process of disinvestment. Paragraph. Be that as it may, in this contempt petition, we are required to decide the issue pertaining to willful disobedience of the order in view of the fact that the amount of service benefits according to the respondents has already been paid to the petitioner. We do not find any element of willful disobedience of the order so as to punish the respondents for in this contempt proceeding. However, liberty is reserved to the petitioner to take recourse to such a remedy as may be available to him in law with regard to his grievance.
I appear for the complainant. Yeah. The complainants are employees of the respondent university, working for the last nearly 17 years. Way back in the year 2016, they preferred a writ petition seeking regularization. A mandamus was issued to consider their case. But an endorsement was issued saying that they cannot be regularized. Now that endorsement is quashed by the subsequent order passed by this honorable court in WP at Annexure A. A mandamus is issued.
26.
Court may kindly take note of the fact that on 8/7, a submission was made for compliance. Time may be granted. On 8/7, I request the court to kindly see the order sheet.
26. Oh. The direction is to consider, right?
No.
10th of January.
Consider in the light of the findings recorded in the order.
15 is signature. Yes. And then appointment directed to consider in the light of the Summa Levy. Then the division bench is 43.
The division bench, a contention was raised that it is the government which has to consider, and therefore they have no power to regularize. Now that has been negative. The kindly see page 34. This was the argument advanced at page 34 in the writ appeal. That has been negative.
So what is the non-compliance? What happened? There, your services have not been regularized.
No, we have not been regularized.
This is the content.
On the contrary, the same stand is repeated that the government has not permitted them to regularize.
They have considered your claim or not considered? Your cases.
They have not considered my claim at all. They have not considered. Not considered.
Yes, Mr. A7.
Along with the regulation, counter affidavit. Now what is an act? That came into effect on the 16th of February. There are not state has enacted this section 2. Establishment in public sector means your application.
Yes.
That leads to the next page, Roman 5. The government university is they are a government university. And he is the private. I go to the government. The university, even if we want to do, there's a private. We have the university department.
Where is the endorsement?
Page 13. Connection R3.
We only inform that you know that act here are regularizing. They have to challenge the value. This judgment. So
Yes, all right. Yes, Mr.
Yeah.
Yes.
Now this enactment was passed. I request the court to kindly note the dates. This enactment was passed on 19th October 2020. Long after that, the writ petition came to be allowed on 16/7/2021. The writ appeal itself came to be disposed of on 10th January 2022. Not a whisper either in the writ petition or in the writ appeal under that. Constructive res judicata.
Yes.
Be that as it may request the court to kindly peruse the provisions of the act. I will show that has no application to a university at all. The respondent is a university.
Yes.
Page 7, annexure R1.
Yes.
Kindly permit me to read the statement of objects and reasons. The Honorable High Court of Karnataka and WP number so and so and in connected cases has directed the state government for absorption of employees in public sector enterprises, kindly mark it, only for persons from public sector enterprises who are working on deputation into the government departments. We are not working in any government department. We are not working in any public sector enterprise. In the above circumstances, state government was under an obligation for absorption of the petitioners who are the employees of public sector enterprises into different departments of the state government and municipal councils. The establishments in public sector face closures due to various reasons, and the employees of such establishment in public sector tend to demand their services to be absorbed against posts, etc., etc. In order to prevent absorption of these employees of public sector undertakings, enterprises into state civil services, it is considered necessary to enact the Karnataka State Services so and so, so and so, so and so. Accordingly, the act has been enacted. Now, kindly come to the provisions at page 8. Once again, preamble reiterates, it is only public sector undertaking employees who face closure and who have been deputed to government departments are debarred from being regularized or observed. The preamble says. Now, what is very important is the all important section 3. I request the court to kindly mark. So, notwithstanding anything contained in any law, contract or agreement or any judgment, decree or order of any court, tribunal or any other authority or any order or proceedings of the government or any officer of the government, no employee of an establishment in public sector shall be entitled to absorption into public service from the date of commencement of this act on any ground whatsoever, including that such establishment in public sector is closed or is likely to be closed, or the employees has worked or has been working in any department of the government on deputation, on contract, or on office duty accordingly. So this is only for absorption of employees into a department of the government. It has no application to the university. And what is important is absorption into a public service. Public service is defined. I request the court to kindly note. Section 2C defines public service. Public service means a public service of the state as defined in clause 3 of section 2 of the Karnataka State Civil Services Act. So we have to fall back on the Civil Services Act. I request the court to kindly note the definition in the of public service in Civil Services Act. It says public service means a civil service of the state and includes a civil post under the state, the secretarial staff of the houses of the legislature, and office and servants of the High Court. Only they are civil servants or public in public service. We are university employees. We do not come under the definition of public service at all. So this is not an absorption into public service. Nor are we on deputation from a public sector undertaking, which is again defined. Kindly permit me to refer back to establishment in public sector at section 2(1)(a). 2(1)(a).
Yes.
Establishment in public sector means a government society registered, a cooperative society registered under the Karnataka Cooperative Societies Act. We are not that. A government company, we are not that. A local authority, we are not the local authority. 4 is important. A statutory or non-statutory body or corporation incorporated by or under a state or central act owned or controlled by the state government. So we are not one such corporation or board controlled by the state government. Then a government university, can you mark it? University is covered, but only a government university are deemed to have been established by or under any law for the state legislature. Ours is an autonomous university, not a government university, established or deemed to be established. Therefore, we are not employees coming from a public sector, number 1. We are not employees demanding absorption into a public service, because public service is confined to civil services or high court officers and servants. Therefore, this act has both this thing. this is the grossest disobedience, willful disobedience, and the act itself was prior to the passing of the mandamus. And therefore, now they say in the endorsement, your case will not be considered. Court said you consider our case. Kindly see the endorsement. They said we will not consider your case. Therefore, it is a willful, deliberate, highly premeditated act of inventing excuses after excuses to deny employees working for 17 years the right to be regularized in service. And therefore, accused will have to be called to the court and proceeded against and punished for disobedience. Please.
Yes. Thank you. Huh? Which case? We have dismissed. What is this case about? Huh? So what is? Just a minute. This order has been already adjudicated, right? So it is appeal against this order. Huh? No. Appeal not against this order. Wait. Don't worry. You have filed appeal. This appeal against which order? Huh? So this is the order. What is to be? You argue? Huh? This cannot be a ground. Telling a court not to hear the case is something.
This order is not passed by His Lordship. The impugned order is not passed by His Lordship.
No, but how many? What is the same issues in what? How you can file multiple petitions for same relief?
Somebody else.
Huh? This is somebody else. Oh, all right. I'll let him be. Yes, all right. You are right. We will refrain, but there is a way of telling people. Not, right. Learned party in person, additional government advocate. Party in person has placed a copy of the order dated 3rd of September 2019, passed by one of the members of this bench within bracket, write my name in WP number 21456 part 2019. In view of aforesaid, let this appeal be listed before a bench in which one of us, write within bracket, is not a member. You can't give the date. No, we can't. It will be listed whenever make mention. Yes. This petition has been, this is what, 29. This petition has been filed of non-compliance of the direction, non-compliance of the order dated 16/7/2021, passed in WP number 34001 bar 2019, by which the writ petition preferred by the petitioners was disposed of with the direction to the respondent university to consider the case of the petitioner for regularization, bearing in mind the observations made by the Supreme Court in Uma Devi versus State in Srimati Uma Devi versus State of Uttar Pradesh, 2006 bracket close 4 SCC page 1 paragraph. Learned senior counsel for respondent while inviting the attention of this court to the averments made in the counter affidavit filed on behalf of the counter affidavit submitted that the state legislature has enacted the Karnataka State Civil Services within bracket prohibition of absorption of services of the employees of establishments in public sector into public service bracket close Act 2010. It is 2020. It is further submitted that that in view of Section 2 within bracket Roman 5, the Act applies to the university, and therefore in view of bar contained in Section 3 of the Act, the university, the respondent, the accused could not have considered the accused has and therefore in view of bar contained in Section 3, the accused has bar contained in Section 3 about regularization of services of an employee, the respondent, the accused has considered the case of the petitioners and by an endorsement dated 6/5/2022 has informed the petitioners that it is not possible to accede to the prayer for regularization of services made by the petitioners. It is further submitted that the directions contained in the order have been complied with, and in case and the petitioners are at liberty to take recourse to such remedy as may be available to them in law with regard to their grievance. Paragraph. On the other hand, learned senior counsel for the petitioner, while inviting the attention of this court to the preamble of the Act as well as various provisions, has submitted that the Act does not that the Act in question does not apply to the case of the petitioners, as the petitioners are the employees of the university. It is further submitted that the university is an autonomous university and is not a government university. It is also urged that the petitioners have not been posted on deputation to a government department, and therefore the plea the plea taken by the respondents that their services that the plea taken by the accused that the services of the petitioner cannot be regularized in view of the provisions of the Act is barred by constructive res judicata. Paragraph. We have considered the submissions made on both sides, full stop, by an interpretative process. The accused cannot be held guilty of committing contempt of this court. It is pertinent to note. Full stop. It is no, not pertinent. There is no element of willful disobedience on the part of the respondents. We are therefore not inclined to proceed further with this petition. The same is accordingly disposed of with the liberty to the petitioners to take recourse to such remedy as may be available to them in law with regard to their claims. With the aforesaid liberty, petition is disposed. Yes. Complied? No. Complied? Huh? What? Council for Respondent Praise Fund is granted 2 weeks time enable him to file the compliance report. 2 weeks time. What? 2 weeks time. What?
Education matter.
Oh, that order is there. Where is it? Undertakes to comply with office objections within 1 week. Third is the order, right? Yes. Third on the question of admission as well as there is a delay. Third on IA number so and so, right? Issue notice. Learned additional government advocate submits, right? Then up to this. Here, bracket force. All the three cases, same 34, same order. For reasons assigned in the application duly supported by an affidavit, it is directed that let notice be published for appearance of respondent number 2 before this court on 22nd September 2022 in daily newspaper published from the Prajavani Kannada edition published from for Bangalore edition, right? Accordingly, IS 1 of 2022 is allowed. Yes, madam, what is it? Recalling. Yes, you don't even remember the way you are making this thing. From your expression, we can make out. No, nothing. Nobody has else. This is all Mr. You, why don't you read the name? Sumangala Swami is the name, right? Why don't you read? She will say no, Sumangala Swami. Not appearing. You are not appearing. They read both the names. He doesn't know why are you troubling him. He has forgotten about it. Reasons assigned. IA1 or delay for the reasons assigned taking into account the fact that expressions of sufficient cause should receive liberal construction, delay in filing the IA recall of the order dated 3rd of July 2019 is condoned. In the result, IA so and so is allowed. Order dated 3rd of July 2019 in WA 3135/2018 is restored to file. Restored to file. Let the same be listed for orders on admission. Oh, don't say anything. 2 weeks time is granted to comply with office objection. 37. What correction?
Hearing
152, 60 days. Fourth line, 5. All right, yes, done. IA is allowed. Action. IA. Right, IA is allowed. What is it?
The idea is to-
No, compliance report filed, madam. No compliance report have you filed? Last date of hearing you were given time. Yes, this all relevant data. Relevant data and documents have been collected. Compliance report has been prepared and the same shall be filed within 1 day. Did you file it there after 7th March? What part? Huh? Huh? Yes. One minute. 1 minute. Give us 2 minutes. We are going through this order dated to 18/12/20. Just give us. What is amended petition? So see the directions were twin directions. They have to maintain the existing parks and gardens in the city and make improvements in the existing parks. These were the directions, right? Initially. Thereafter you have amended. What? Mr. Additional prayers.
The modified the act of vested with the private and mutual funds with multiple entries and receipts in order to prevent encroachment by the respondent. In respect to the parts and places open for the private individuals, Respondent going to create a centralized web portal to place a list of parks and places open space for the entire state. Also, web portal to have a grievance or complaint resolution system to enable this. All guidelines and intervention to purpose of that is a total authority. It will be prayer for us. Suggested. Act was incorporated in 1985. Thereafter, to match the present day demand of because the act is not upgraded. Therefore, in this background, some of the parks are encroached. Either not by the corporation or the BDA by putting up various structures which are diminished to value. One such incident was I pointed out by order dated the 9/11/2021.
Yes.
State government has also tried to submit the report of illegal construction to the parks and place. DDP has not submitted the survey report and state government has also not submitted. After this month, they find a report. The report would immediately address the statement. Apply to BBMP of particular partner. I was trying to point out that these are all stray instances where the buildings are constructed before the government. Okay, Mission report after considering the submission directed BBMC to get the report. The construction was done by the partner. BBMC has sent the report on 15th of December 2021. So this we have constructed the sports club, appears to be a sports club. Not, it is given to private parties for running the sports club for commercial.
Yeah.
My amended petition to not just to page 18, next G. Amended petition. Ladies, we were paragraph 7 on the petition.
Yes.
No. The report which is right, they sought to justify this on the ground that not all three parts put together is less than 5% of the party. Therefore, constructions for this. Much is to see marks report dated 15th of December 2021, filed by second respondent.
There's 15. Yes.
Page 12 marks, document number 2. It is an extract of CDP, which I am also placing reliance upon by you. Existence of 3 parts in admitted. And it is also admitted that notes 3 parts are referred to.
So 9 park, they say that they have this thing. 9 park, they have made substantial improvements. 3 require some improvement. And this is a memo you told us. 15, 12, 21, right? So then 1 page, right? 2 page.
21.
21. Oh, then something else. Also 15, 12. What you are trying to tell us? Improvement in which part? Okay, exists on record. 22.
Volume 1. Is there along with volume 1?
Volume what?
Volume 1.
Have they responded to your amended petition prayers? No. Ah. Okay. 17. Some sort of a map, right? This map. Ah.
There is a code.
Ah.
Now, road in between 421 is now not there.
Hmm.
422 is entirely.
So this 422 is what? Is a park? This is which area? Chhatripuram. So your grievance at this point of time is that 422 is not there.
Legal constructions because it is prohibited by the. This part has this concession and handed over to the parties. But there is a prohibition in the section that any arrangement between the parties of this nature is valid. So therefore, there is no question of exploiting it commercially, giving it to third parties.
Of course, so we'll have to. So now one by one, this is a continuous process, right? And all the so presently you have told us about 222 in Chhatripuram. Yes, what do you say? Ah. No, 422 park is there. Yes. Oh. Ah. Ah. No, but this what he says between 421 and 422, right? These two parks, there was a road. So you will have to respond to this. Really? What objection? No, let them respond. We will appoint. Just first of all, let's ascertain what is it.
But I'm not placing something which is they don't have to that. All the four sides it is not there. This
22.
This on the top on the right hand side there is a mentioning of it. Right hand side top.
Yes.
Today, trying to show you what city. Check the road exists. But it is not for me, not what I'm trying to say. This 422 is example. Now, unfortunately, I'm trying to see the he says, park sites, there is a permission for I don't know if I'm not updated or this. Officers are.
No, let him respond to this. We want this thing response, and then perhaps we can determine what is it. Yes. Yes, right now. Yes. Yes, in this 1 minute, we'll come to it later. Don't in this petition, in this public interest litigation, a direction is sought to the government of Karnataka and its local bodies to maintain, develop, improve, and protect the public premises in the nature of play fields, parks, spaces which are meant for public use. Full stop. thereafter by way of an amendment, it has been allowed, right? The by way of an amendment, the petitioner, the following prayers have been added in the writ petition, right? This is to kindly direct, etc. Don't do this. Yes, paragraph. Learned counsel for the petitioner stated that has learned counsel for the petitioner has invited the attention of the court to a memorandum dated 15/12/2021 filed on behalf of document number 2 of memorandum dated. Document number 2 of memorandum dated 15/12/2021 passed filed by BBMP and has pointed out that what plot, this is plot bearing number. What is 420? What this is what number? That the area marked with number 421 and area marked as marked with letters 422 is a park. It is further submitted that in between the aforesaid two, there was an existing road. It is also contended that the area shown with number 422, which was reserved as a park, has been encroached, has been completely encroached, and the road is also, and road in between 421 and 422 is not in existence. Full stop. In view of aforesaid submission, learned counsel for BPMP, praise fund is granted. But you know it, right? So a week's time, week's time to enable him to file a statement of objection. No, file a status report with regard to the status report. That's it. Now what matters? So we have taken up this issue right today of this. So what you have to say? I mean, you will also file a status report. Acha, all right. So then this thing, BPMP and state government shall file a status report. Who? He is appearing. See, talk to him. He has published. So what we feel is that issues can be addressed one by one. We don't know this broadly. I mean, yes. So you tell us, we will deal with this issue first of this in Sheshadripuram, right? You write that in so and so Sheshadripuram, right? So you will file the response within 1 week. Not status report exactly. Yes.
CTS number.
CTS number. So it's CTS number 4. CTS number 421 and whatever numbers have written before that you write CTS number. Right. Which date, Mr. Srinidhi? 3rd August. Rest on 3rd August. What amendment, madam?
Appear for the response.
Yes, Mr. Naganand, what do you say?
My
Amendment
lord,
about,
I have objection, my lord. I filed my objection statement. My lord, the
no,
case.
to prayer for amendment.
Yes, my lord, even for that, my lord, I have objections. The reason is it completely
Ah,
changes
yes,
the
yes.
complexion.
Yes. Yes, madam, what is it?
Council may kindly use the mics, my lord.
My, he is unable to hear. My,
Notification wherein courts for filling up civil judge posts were called for on the ground that it violates provisions of the Rights of Persons with Disabilities Act. Now, my lord, the civil judge recruitment rules, Karnataka 2004 rules, there is a limitation there as well. It is legislation rules prior to this act, where this restriction is there. I want to just amend it. Ultimately, the issue is all the obviously along with my colleagues.
what is the status of this recruitment notification? We think process is complete. Everybody has been selected, right? That's the what it is. This is complete, madam. How can we, the persons who have been selected, they need to be included in case you want. Subject to result. No, so therefore.
Ultimately, our issue is not to disturb other persons. We are saying adequate reservation is not provided for persons with disabilities.
No, so far as what we are trying to tell you, so far as relief of quashment of notification dated, since the process of recruitment at this point of time is over, we may not this thing set aside that order and quash it. So only to the extent means what?
Ultimately, there is an order that the final selection is done is subject to the outcome of this decision of the court.
That is always there, even if we don't say. Yes. So
therefore, the amendment.
No, but you must come out with this. We are asking you, right? If the process is complete, right? 16. So we can tell you that these newly recruited judges have been administered oath and they have joined. They have been posted to various posts in the state of Karnataka, that we can tell you. And they are undergoing. They will be reporting for training from 16th of August. That is with regard to quashment of your notification dated 26th March. So we are just telling you. Addendum to the notification, provide reservation.
Only that if the law is being additional reservation.
No, we are just, it's just a query. We are broadly discussing that you have made 3 prayers in the petition. What will be the impact of subsequent events on these prayers? That's what we want to know. How many, annexure, just a minute, annexure D, how many posts were advertised? How many vacancies?
Uh,
74,
2 months.
90. But this, we have provided this thing, see, madam, physically challenged 3 is provided. Ah. Remaining will be advertised. Remaining posts which have not been fulfilled will be advertised again. No, that is subsequent this thing notification. Now that's what we are saying that so far as in we can tell you. Yes, Mr. Nagaran, what happened to this notification 26th March?
My lord, that notification, my lord, has been have worked out. The numbers your lordships will get, my lord, total number of positions were 74 plus 20, that is 94 vacancies. The recruitment process, I understand, my lord, is completed, and postings are to be given after the training is over. Now, my lord, the submission that I'm making is.
How many candidates have been selected?
My lord, that information I don't have, my lord. I can.
So you please file. I mean,
yes.
You have not filed statement.
I filed my statement of objections to the main petition, my lord, and I've also.
How many persons have been selected? Who are they? Please tell us.
At the time,
they
my
will be
lord,
the persons who will be affected by result of this litigation. They are not before us.
I place that.
Record the statement as senior counsel says that she is not challenging their appointment. Now these vacancies remaining, so therefore we will have to ascertain what are the, you seek instructions, what happens to remaining vacancies. Make a statement now.
Yeah. Now,
in view of events which have taken place.
Yeah. Only one submission I would like to make is this, my lord. The entire basis of this petition, if your lordships could see the main prayer in the writ petition, is also one.
Yes.
The first point, my lord, is to hold that Annexure D is not in accordance with law. The second prayer is mandamus to issue a corrigendum to make this reservation. Now, my lord, we have pointed out in the statement of objections that there are rules formulated and those rules are not challenged. That is the reason why now, my lord, the whole frame of the petition is that there is no reservation at all and that should be given to them. Whereas we have pointed out in the objections.
No, Mr. You apprise us with regard to status of process of.
Yes, I will place that on record.
How many this thing? We'll find out.
Yes, because by the time we file the statement of objections, the recruitment process has not yet concluded. I will now place it.
We believe it's complete. You point out how many persons appointed, what happened.
Please, ma'am. In a week's time, I will file it.
Learned senior counsel for respond number 2.
Respondent
number 1. One trace fund is granted a week's time to enable him to apprise this court with regard to status of recruitment notification dated 26th March 2021. List after 1 week. Yes, many cases, right? Tell the date. There's no urgency, madam. Now nothing can be done. You understand, right? The whole thing is over. We are you find out the vacancies have been filled up. They have been administered the oath of the office. They have joined. It's seeking question. No, see, this thing, madam, is that now probably this challenge may not survive in the sense that remaining vacancies will be notified again for this being filled up. So perhaps at that time, you will have to assert that if in that notification, again a reservation is not provided for these people, we don't know. This is just broadly thinking, whatever. No, we are not submitting anything. We are not petitioners. 8th August. 8th August. 11th August. 11th. 11th August.
Please.
Yes. Been posted yesterday to the meeting of 53. They all have been posted. They will come on before 3rd of August. We are giving farewell to justice. They are funds. So we have been their posting. At this stage, bringing a lot notice of IA2 of 22, 3 of 20 of 2022 to propose the draft of disease is phone number. For results assigned IA3 of 2022 duly supported by an affidavit delay of 22 days in filing the application for recall of the order dated 2/6/2022 is condoled, heard on I. Accordingly, same is don't practice. Then heard on IA2 of 2022 for reasons assigned in the application order dated 2/6/2022 is hereby recalled. In the result, IA number 2 of 22 and 3 of 2022 are allowed. 2 weeks line below. 2 weeks time is granted to comply with office objects. Issue notice of IA1 of 2022 to propose the loss of disease respondent number 3. 3, 4. 3, 4 or 3? 3. All right, so it can be allowed, right? Within limitation, right? Heard on IA, delete that. Heard on IA number 1 of 2022. The results assigned in the application which is duly supported by an affidavit, the same is allowed. Let amended cost actually be filed within 1 week. Interim order, if any, shall continue. Heard on idea number 2 of 2022, an application seeking substitution of LRs of disease applicant for the reasons assigned in the application which is duly supported by an affidavit, same is allowed. Let amended cost actually be filed. The LRs on record, not substitution. This is substitution. What is it bringing LR? Which application? Delete that. Yeah. What I need to know.
Appellant to represent as LR of deceased respondent number.
Substitution, right? Represent as LR. What does it mean? So for the reason defined in the application duly supported by an affidavit, the applicant is permitted to prosecute his appeal as legal representative of respondent number 2. Everything all in one, setting aside abatement, everything, right? Good. IA is allowed. And then this is on IA. We have passed an order. We will list it for order. Let the appeal be listed for orders on admission. Yes. It's on 11th August, 4th August 2020. 4th August. Hey, Mister, this is not, it is not listed for admission. We have not read it. It's on IA. We have not gone through your file. And you know how we can't afford to depend on the councils. We have to do the homework. So, that's why we are not, next date of hearing we'll go through your appeal. That day you give us 4th August. This is a writ appeal. We will go through the order passed by the Lawrence Single. Give it. But we cannot say whether it will be there or not. It will be, Mr. Raj, it is misplaced, right? Paper branch people will keep synopsis with them. They are very fond of it. We will keep it. You give them 2 more copies so that they don't misplace it, right? They are very fond of synopsis. They keep it there and they read it. And they don't assist us in delivering judgment. That's it. You give it. Keep it. Yes. 4th August. Yes. Yes. This what? Why should you make this thing statement? What action have you taken against your counsel? Tell us.
After withdrawal of the writ petition, the appellant had moved the Karnataka appellate tribunal by filing an appeal on 17th of August 2013.
No case. What is it? Why? I mean, you have withdrawn your writ petition. No. This is surprising that you have withdrawn your writ petition. You file an appeal against that order also. Nothing adjudicated. You don't know. Then that's end of the matter. It is, if subsequent cause of action has arisen to you, you are at liberty to take it. Where is the affidavit of the council of ideal? All this is right. Everything, I mean, once you have become a council, you have got license to do anything, right? License to argue anything, license to plead that I don't know, license to withdraw the petition, license thereafter to say that no, it was wrongly withdrawn. Who was the council? Who withdrew it? Where is his affidavit? This all will not encourage this. You have this thing, you have filed a memo. It's not oral submission. Who is the counsel who has withdrawn? Where is his affidavit? Not nothing. You have filed a memo, right? Then, see, just right.
The fact that appeal was also filed returned, saying that the appeal would not be made.
Filed a fresh petition, whatever.
No, fresh writ petition was filed as against the order passed by the KAT.
As against the order passed by Deputy Commissioner, not to pay page 73.
Don't see any reason.
That order was at page 78. But he was file application because the previous people. Order was in the page 78 in paragraph. You don't know that the previous the petition
You have not told us who was the counsel who had appeared. Where is his affidavit? Nothing. Fine. Nothing. This intra-court appeal has been filed against an order dated 15/2/2017, by which Lawrence single judge has dismissed the application seeking recall. The application seeking recall of the order by which the writ petition was dismissed as withdrawn. Paragraph. We have heard learned counsel for the appellate parties. The mark is present for. We have heard learned counsel for the parties. Full stop. The petitioners had filed a memo seeking leave of the court to withdraw the writ petition, namely WP number 21389/2010. The aforesaid memo was signed by the appellant, to stop, on the basis of instructions issued by the petitioner, not appellant, right? Appellant, comma, the writ petition was dismissed as withdrawn. There, appellant have neither the learned counsel for the appellant has neither chosen to indicate the name of the counsel who had appeared before the learned single judge, nor the affidavit of the said counsel has been filed stating that he withdrew the writ petition inadvertently. In fact, the writ petition was withdrawn on the basis of memo filed by the appellant himself. Full stop. We therefore do not find any ground to interfere with the order passed by the learned single judge. In the result, appeal fails and is hereby dismissed. Thank you.
My lord, in this matter, I appear on behalf of the appellant, my lord. My lord, my lord, I appear on behalf of the appellant.
He is telling us that you will argue that because there is an audio problem. Go ahead. He will argue. Yes.
My lord, the short
senior counsel is telling us you will argue. There is an audio problem, right? Can you hear it? No, can you hear it? Yes, that you will argue. Go ahead. Yes. Yes, Mr.
My lord, my lords, I appear for the appellant in this matter, my lord. The short question that arises for your lordship's consideration is whether an employee of the appellant, my lords, whose
There's
wife.
some audio disturbance.
I'm so sorry, my lords. Could I request that the matter be listed next week, my lords? I will appear in person and argue, my lord.
Subject to video conferencing. There is an audio disturbance, therefore the arguments could not be heard. Right.
Could it be taken up next week, my lord?
Lord, serial number 46, I appear for the appellant.
After 1 week. Yes.
Lord, serial number 46, may I request the matter to be passed over? My senior is on his legs in another court.
Yes.
My lords, I appear for the appellant. Request a short passover.
Sir, 47.
My lord, I'm not keeping well, my lord. Kindly have it next week, my lord. I'm not keeping well, my lord. Maybe call next week, my lord.
And counsel for the petitioner submits that he is unwell and therefore prays for adjournment placed in the next week.
I beg to appear for petitioner, my lord.
So,
This
the morning is appearing for petitioner. How can you appear?
49, my lord.
Sir, this. That is 48, sir.
Sorry, please.
Yes. Yes. Huh? Implement some orders of Supreme Court. Nineteen. Yes. Allowed. Are the orders of which we want implementation? 21/11/2014 and 7/9/16, right? And 7/9/16. By this. This is by division bench of this court. What is it? Yes, 5. No. What is memo and all? That's fine. What is it? Yes, which order there's not? Yes, which order you filed the SLP? Which order? All right, so that has been dismissed. Yes, fine. Appearance of Mr. Mohan means public interest. He doesn't appear for regular litigation. He is a specialist in public interest litigation. What is it? 10 March. That has been dismissed. He is telling us. So they are saying that they will now take action for implementation. Some time has to be given to them. How much time? You will have to. So see para 7 of this order, 10th of March 21. 10th March 21. Widening of roads. So then you have to tell us within how much time will you take a decision? But No, no, so you'll have to tell us within how much time you seek instructions and then tell us, right? When will you tell us? This petition, write down this mark be present in this petition which has been filed as this petition which has been filed as public interest litigation, comma, the petitioner seek a direction to the respondents to implement the order passed by the Honorable Supreme Court dated 21/11/2014 and order dated 7/9/2016 passed by a division bench of this court. Paragraph. Admittedly, the state government had sought an application for modification of the order dated 21/11/2014 passed by the Supreme Court, comma, which has been dismissed by an order dated 17/5/2022. Paragraph. In view of aforesaid order, council correspondent submit that that the state is under an obligation to give effect to the directions contained in the order dated 21/11/2014. 21/11/2014. And the subsequent order dated 7/9/2016. And division bench is 17/5, 79. And an order dated 7/9/2016 passed by a division bench of this court. Let the directions. So next week, will you tell us certain learned additional government advocate prays for short accommodation in order to enable him to apprise the court with regard to the time frame within which the aforesaid direction shall be implemented by the state government. List on Friday. What Friday? Not this Friday. Friday. Next holiday, 4th August 2020.
I beg to appear for petitioner, my lord.
Now your case is called.
Yes, my lord. This is the case, my lord. The petitioners are seeking transitional area has been declared by including the Gram Panchayati, which is not less than 10,000, my lord. They are only the 3,000 population is.
Statement of population. Yes.
3,000 the population Gram Panchayati having those who are only ST people and SC people, my lord. No, not more than the peoples are available. That is the statistic we have submitted to the Deputy Commissioner. But still they have recommended, this Gram Panchayati has been recommended for transitional area to the Sirur Gram Pattan Panchayat. Page number 22, my lord, that is the notification which was issued. And we have filed the objection statement stating that this is the Gram Panchayati established only 4 years ago, my lord, and suddenly now included in the Pattan Panchayat, my lord. That is why, my lord, we have submitted our detailed objection, and population is less than 3,000, my lord. And still, my lord, because as per the notification, 10,000 should be there. Not more than 20,000. And now, my lord, this Gram Panchayati has been included in the Sirur Panchayat. Page number 34, my lord. The objection is also considered, they have stated.
You should be happy, right? You have been included in a town place upgradation, right?
Yes, my lord, upgradation.
So you should be happy about this upgradation instead of making a grievance. Why do you want to continue in village panchayat?
Because, my lord, only 4 years ago, my lord, established the Gram Panchayat. And the people of Neela Nagar, my lord, all are ST people, my lord, and SC people, my lord. Lambani community,
No, but
only people's
no.
population is available.
So they are entitled to better facilities and entitled to live in a town. That
No,
doesn't mean that they should always live in a village.
Because, my lord, there is no agriculture. We are staying at a hilly area, my lord. Hilly area, and it is not at all developed. Gram Panchayat established just before 4 years, my lord. We have not benefited any facilities from the central or the state government, which are Narega. All these facilities is not at all fulfilled by the Gram Panchayat, my lord. And we are waiting for that because we have to take development from the union and state government, my lord. But now, my lord, there are several villages adjacent to the Gram Panchayat, my lord. Gram Panchayat, there are more Gram Panchayatis are available adjacent to the Sirur, which is away from the Sirur, my lord. This Gram Panchayat has been taken into consideration. Now, my lord, our division bench for relating to the other district, my lord, Vemgal district, my lord, in that population only they are the agriculturists, therefore it has been deleted from the Patan Panchayat. Here is a case, my lord, only 3,000 people Gram Panchayat was established, but that 10,000, less than 10,000, how can, my lord, they have to take Gram Panchayat? According to their own notification, my lord, it cannot be included in Patan Panchayat.
All right. Page 34. It is issued under which provision?
Section 3 of Gram Panchayat.
49 or yes. Delimitation is done, lots of times, you will carry the category is one of the groundwork in the division. It cannot be groundwork. To say that. Then English only was two small numbers because I take this 0. Made it as a yes. Government education is largely they have to file objections. Notices have been issued. Without invitation, they won't respond. So we have to extend invitation to them to file objections. How much time? Current council correspondents pray for and have granted 10 days time to include them to file objection. Let them file. He'll consider next date. 51, it's already have government advocate. Yes, what happened? Fine. We should. Okay. Heard on IA 1 of 2022 proposed. No. Heard on IA 1 of 22 legal representatives of diseased complainant are permitted to prosecute this contempt petition. Accordingly, IA 1 of 2022 is allowed. Issue notice. The 52, the Aditya Narayan, take up a little later. Second half, we'll take it up. Yes. Whatever after motion here. This is that yes. Oh, why? The Red Council for the petitioner submits that the directions have been complied with. He therefore does not intend to prosecute this petition. Full stop, a memo of withdrawal has been filed, which is taken on record. Accordingly, the petition is not complied.
Yes, some subsequent development.
In view of subsequent events which have taken place, the Red Council for the petitioner does not want to prosecute this petition. He has filed a memo seeking leave of this court to withdraw the petition. The same is taken on record. Accordingly, the petition is.
My lord, I appeared for the petitioner, my lord.
Yes.
My lord, Shimoga Urban Development Authority formed a layout of residential sites and called for applications for allotment of the sites.
Under section 7(2)(a), how we can challenge it? I don't know. Yes.
My lord, totally 6,556.
Oh, who are you? This is public interest litigation. Please tell us
my
about.
lord, with regard to locus, I was a complainant before the locayucta. Your lordship will find it at page 114.
So what is the element of public interest in this petition?
My lord, My lord, there are illegal allotments. The Lokayukta gives a finding that allotments are illegal. But in some cases, he says, although it is illegal, reconsider their applications if they are eligible to. That is, a special preference is given to the person whose allotments have been set aside as illegal, but ordering that let their applications be considered once again. Those who did not get allotments, they don't have the benefit of their applications being considered.
Yes, go ahead.
My lord, your lordship will find the illegal allotments that were set aside was, although there was no discretionary quota, 142 sites were allotted under the discretionary quota.
So it's only a recommendation, Mr. There's no order. What is it under section? This is a report under section 728. Investigated the local 2A not standing. Investigate an action. This is the report. What is challenging? 2020. Not
partial implementation is partially there.
To surgery for Washington 2020. It was reading.
So for a direct reconsideration to the next payment.
This is under seven to a rate with 12 So it's only this thing, recommendation, right? It has to be acted upon. Hey, Mr. You have to, there's no point in keeping, looking at us. Please argue. We are listening. You are not arguing anything.
My lord, under section 12, kindly turn to section 12 of the Lokayukta Act.
Please. Yes, argue. Yes. 12.
12, my lord. If after investigation of any action involving a grievance has been made, the Lokayukta or Upalokayukta is satisfied that such action has resulted in injustice or undue hardship to the complainant or to any other person.
Competent authority.
Any other person. My lord, various other persons made the applications. They did not get the allotment. Injustice is really caused to them.
Those allottees can approach this court. It's not your case that on account of.
No, my lord, I was my lord. It is I that made the champion.
No.
My lord, it is I that made the complaint to the Lokayukta, saying about the illegalities. My lord, there is something here, my lord. My lord, it is I that made the complaint to the Lokayukta, complaining about the illegalities in the matter of allotment. It is pursuant to my application. The government referred the matter to Lokayukta. Now, my lord, largely I have no grievance, but wherever the Lokayukta says that the allotments are illegal, but to reconsider their application, my lord, I am aggrieved. Now, my lord, it is I that approach the Lokayukta. It is because my application was made. The government referred the matter to Lokayukta.
20. What they ask him, what he should know if he's a public respected person. But this is 2, right? This 2, 12, 2. Competent authority has to take an action on the report. What action has been taken on the report? What has been done?
What has happened subsequent to this report?
My lord, subsequent to this report, now they have called for applications from those persons whose allotments have been held to be illegal and asking them to furnish these applications, these other things made good. My lord, persons who did not get allotments, they go out of the pictures. Persons who made wrong statements and got the allotments illegally, now their applications are once again being considered.
Those persons, the original allottees, they have not approached the court. They have
Yes,
not
my
been.
lord. My lord, I have met them also parties. You do? Huh? Officials.
The allottees in whose favor originally the grant was allotment was made, they have no grievance against this order.
No, now, my lord, they have to challenge the Lokayukta's order. Wherever allotments have been cancelled, it is for them to cancel it. My lord, as far as I am concerned, my grievance is persons whose applications have been rejected earlier, they remain outside. Injustice is caused to them. But persons whose allotments were held to be illegal, they have been given preference saying that reconsider their applications, make good the defects, even if there are defects. My lord, that would be an injustice to other persons as said in section 12 of the Act.
If the other persons comes to the court, we will consider it.
My lord, whether the question would be, my lord, since I am the complainant before the Lokayukta, and even I gave my land for the purpose of layout, thinking that public will be benefited, whether I have locus or not. My submission is I have.
That we will decide. But our question is simple. Whether the persons who are aggrieved by this report, are they unable to approach this court? Is it your case that they are so poor or so illiterate that they are bonded laborers, so therefore they cannot file this petition and you will espouse their cause? Is it? It's not, you have not said so anywhere in the public interest litigation. That is, let them, whosoever is aggrieved by this fresh invitation of fresh application, let them approach. We will consider that.
No, not fresh applications. Not fresh applications, my lord. The defective applications are thought to be reconsidered.
Reconsideration of allotments, right?
Yes.
That's what he told. Yes, please.
My lord, possibly the others whose applications are earlier rejected or not considered as sites were not available, they can also come before the court.
That's what they are saying.
My lord, the question would be whether I have no locus to come before the court since I was the complainant.
No, it's not a question of this. Is what is the element of public interest? Nothing.
Element of.
Illegally, there is a finding. Illegally, they are finding, but we consider some of it.
Yes.
My lord, the element of public interest is there were 6,000 and odd applications and several thousands of applications were rejected and illegal allotments have been made admittedly. Now, these persons who gave false information and whose allotments were held to be illegal, their applications is ordered to be reconsidered. That means the public at large, that is the original applicants, injustice is caused to them. This is the meaning of section 12. My lord, that is the public interest.
Yes. Anything else? That's all. All.
That's all my submission.
All. Yes. We'll consider. Thank you. Yes.
The 55. My head told me. Different grounds for that they have to take.
All right. I'll find. How much time? There is only, Mr. What short submission is that you issue show cause notice on ABC ground and pass an order on D, E, and F. That's the submission. How much time? Okay. So you respond within, say, 10 days, Mr. Uday Olal and Senior Counsel heard on the question of admission. This on behalf of respond number 1 is accepted by Mr. Vijay Kumar Patil. Who appears with you? Okay. Yes. Mr. Jan Chidappa, learned Senior Counsel with so and so appears on KVA and
Respondent number 3 also you can take.
2 and 3. 2 and 3 appears on KVA, accepts notice and don't appears on KVA and prays for 10 days time to enable him to file objections list on which date? August. 10th August. All right. 11th is working, right? 11th August. It is shown in green ink, so there was some confusion in the calendar. We are told it's working. Yes. Great. Yes. Yes. 50. Yes. Oh, after the break. Yes. Yes. All right. We'll hear you after.
Serial number 12, my lords, if I can mention. Agent. Well, serial number 12, my lords.
It will be taken up in post-lunch session. We have yet to finish.
Similar matter is pending in Supreme Court. They reserved order.
No, this has nothing to do, my lord. That is,
How
this
do
is,
you
my
know?
lord, this is the, against the main appeal.
Knowing what the matter is, you are saying that.
Mr. Kasturi, whenever I will try to put us in trouble, right? Mr. Rao is on the watch out, right? Just he could, the moment.
He's always like that. Anything he could
Alright.
oppose.
Then let the case be called. Yes.
Court officer. Sir. Court officer. Sir. Serial number 49 in reserve for orders, sir.
ಏನಿಲ್ಲ ಇವತ್ತು ಪಾಸ್ ಮಾಡ್ತಾರೆ ಸರ್ ಆರ್ಡರ್ಸ್.
ಹೌದು ಸರ್, ಸರಿ ಸರ್.
ಹಾಕಿದ್ರೆ
ಇದು ನಿಮ್ಗೆ ಏಕೆ ಲೋಕಾಯುಕ್ತ 54 ನಿಮ್ಗೆ
ಒಂದಿನ ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿರೋದು.
ಒಂದೇ ಬುಕ್ಕು ಈಗ ತರ್ಸ್ಕೊತೀರಾ ಅಲ್ಲಿ ಬೇರೆ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತೀವಿ ಕಳಿಸಿ ಅಂತ. ನೋಡಿ ಇಲ್ಲಿರೋ ಫೈಲ್ಸ್ ಮುಟ್ಬೇಡ ಇಲ್ಲೇ. ಹೌದು ಪಾಸ್ವರ್ಡ್
Also, from all those exception of the based on the region, that is implemented village is the modern village of compensation.
So have you submitted any representation? With the case we have. This issue we have dealt with? No. This issue with regard to shifting, have we dealt with in some petition? So have you submitted any representation with regard? What is
Representation.
what has been done?
The public is shifting, right? Move 23 of WhatsApp. Move 23 of the general explanation doesn't provide for shifting right from one village to another village. One kilowatt to another town. It can be only within the particular village.
Yes, Mr. It permits what? Shifting of liquor shop from?
This is the shifting of CH-2 license from one taluka to another taluka.
Oh, which taluka?
Where he is, where his license was, where he was in six taluka taluka. Now he shifted to UCL valley.
Chikballapur taluk to which place? It is rule 23.
General condition of license rules. Shifting of shop. Compared to the restrictions basically the applicants have made permit to license locations from one place to another in the limits of company, in the municipal area, in municipal corporation. Now, that if it is given in village area, it can be shifted into the company. If it is in municipal area, it can be shifted. If it is in the corporation, it can be shifted in corporation. Now, this other direction is found. Shifting from one taluka to another taluka, it is totally different. It is violation of rules. Let's separate what given season. These are all managed in villages, ladies and women focus.
We thought that you have constituted self-help group to this thing, help your members, but it is for public interest litigation also. Yeah.
They come and read. Therefore, we are going to this and shut down all those shops in the area. They are going to
And they go back to Andhra Pradesh after drinking, or they stay here. Yeah. They go back or they stay here after drinking. They go back. Yeah. Yes, of course. Yes, Mr. All right, so this is what. Anything else? Anything else? Good, 5-2.
I'm keeping in mind that
What is this? This is the 5-2A of which rule? Same rule.
the same. Yes, notwithstanding anything complained to the commissioner gave with the rule to secure convenience and regency, safety of the public, or any other reason, we cannot application to basis
It's not a question of rejection. Not it is granted. It's a question of shifting now. Whether it can be shifted, you say fine. But it's you say that it is prohibited under Rule 23. Therefore, can't be shifted. Yes.
23 also it is subject to Rule 5.
Just. You want to file objections or you will file? No. The same. A clear-cut case of cut, copy, and paste, Mr. That's why I said. Oh, that's why we asked him that have we this thing dealt with it? What is that's fine, but you tell us that file objection. Which remedy under which appeal?
Public interest litigation, where is the question of asking? Public interest. Who has to file the appeal? It's only the aggrieved person.
Any person. You are agreed, right? No, they are saying you are. No. Mr. Public interest litigation doesn't mean that alternative remedy does not apply to you. Supreme Court says, right, Guru Ayur gave from Guru Ayur case, Supreme Court has said that doctrine of availability of alternative. See, this is all factual, right? Who comes from where and when, what he does and all that, what they do. Like you told us, right? Should it not be examined by the Excise Commission? If actual, we will say so, they will decide your appeal. Guru Ayur, Supreme Court says that this doctrine of availability of alternative remedy apply. We are not inclined. Why we are relegating you to an appeal is that it's factual this thing. Right? But it's already January, it is shifted, right? 7 months you are. Oh, yeah. What you are doing? To decide within
the time frame.
So, Mr. We will ask them to find an appeal, but you decide the appeal in a time-bound manner. Should not be like this that you decide it within 3 weeks. Right? He will appear.
Let him appear.
Licensee is right. Licensee is appearing here also. He will appear there also. Oh. That's why we asked him, that we thought that, we thought that self-help group has been constituted to help women, but it is constituted for litigation also, engage in litigation, filing PIL. Oh. But we are sure that council is doing charity. Correct. This all happens. But why should you, Mr. How much? No. I love it. You can say so. Yeah. But why you should not file in appeal? Yes. Guruvayur Supreme Court says, right, alternative remedy applies to this thing. Why should you not? No. Why? When you can come here, you can very well file an appeal sitting here, right? No, that's why we are referring. It depends on the facts of the case, mister. This is. You cannot go. Where is that order? You are also appearing with him. Second. Yes. We have something inconvenient questions to ask about your petitioners. So, convicts. What convicts? Are you convicted? Have you been convicted? No. He is saying so.
Petitioners.
That you are convicted. No, this can't be done, mister. Then an objection. Did you, when you approached this court, did you disclose this that you were convicted? No, did you disclose that you were convicted in criminal cases? No, not on an objection being raised by. Everybody who is a convict will pay 25,000 each to the High Court Legal Services Committee. Yeah, this is what. No, this can't be. You can't be allowed to abuse process of law. Where is that order? Of division bench you are saying. Ayla. 4265. What does it say? Which paragraph? Where is the copy, Mr. Judgment? No, it's all facts of the case. You can't. There is no rule. Public interest litigation should be entertained, and you will say that it is not binding in any case, mister, on us. This is a Supreme Court judgment. That's why we want to see. Read it where it is said that whatever everybody comes here, it should be entertained and notice should be issued. Where is that law? Then that's what we are trying to tell him. That's what he's arguing, that every case public cannot go in appeal, and this is what he's arguing. That's what we will. No. We will hold that judgment is per incurium. Mr. 2003-7 SCC 546 has been considered in that case. Supreme Court. Yes. Nothing. Now, what is your this thing, Mr.? What is with regard to violation of Rule 23? We will adjudicate here only, mister. You will lose the right of appeal also. Why? No, wait. Just a minute. Where is it? It's just now ready. 220. Yes, read it.
In case of CH-2, the Deputy Commissioner may permit the licensing if the location of the stop. within the limits of this area, from panchayat area of B from category A, B, C, D, area of category to category E area of item 2 and item 9. So the one of B from urban to rural in the entire district. Anywhere it is, why they are making community? How we are getting what? How are we getting what? The convention of rural area to accommodate that. Because the total tradition is that environment verify the government of one state that the urban shops can go to rural areas. So that the vacancy we created or the vacancy created by removal of the flat. So now this is
All right, so permitted, that's all. Rule.
going to slum. Which is shifted to the rural place. That is within the anywhere in the district is the working rule 23. That's one of
That's it. What else? The only point which he has raised is Rule 23. That's it. Oh, in his petition, he has only raised this issue, Mr. Rule 23. You have said, Mr. Patil, it's permissible. All right. Yes. All right. Yes. Yeah, what happens? What does he do with people coming from Andhra Pradesh? Right? Lighter. There's nothing to be so serious, Mr. Patil. Yes, Mr. Guest from Andhra Pradesh. How we will deal with? Yes. Yes. Have you made any grievance to any authority? It permits, right?
I think that there is absolutely no implication of fighting there by passing the order.
That's it. Yes. You cannot turn a public interest litigation into an appeal granting license, right? At the instance of the persons who have not got it. We understand, Mr. We will conduct an inquiry. Your conduct is not fair, Mr. Your conduct, you did not disclose that you are convicts and this thing is placing it on. Which paragraph of the petition have you said so? Which paragraph that you have been convicted? Don't argue. Which paragraph of not application? We are on the petition. You said that initially you disclosed. Where have you disclosed? Then this is an unfair conduct. You have to come with clean hands before the court. It's better that we deal with only legal issues instead of your antecedents. Fine. We'll deal with it. Since we are deciding this legal issue in this petition, we are not relegating you to an alternative remedy and we are not imposing costs. That you should be thankful to us for that. WP 13468 bar 2022. WP number 11829 bar 2022. In these petitions, the petitioners who are residents of village, petitioners who are members of Ishwaraya Mahila, whatever, women self-help group, and petitioners who are residents of village, petitioners who are residents of Gram Panchayat, residents of Unasena Halli village, Melia Gram Panchayat, have these petitions which have been filed as public interest litigation. There only add Hindi, delete everything then. Write down again in these petitions which have been, in both these petitions which have been filed as public interest litigations, the petitioners who are members of women's self-help group and are residents of, just now you have written, Musen Halli village so and so, have sought for a writ of certiorari for quashment of order dated 17/1/2022 issued by Deputy Commissioner Excise, by which respondent number 3, namely CL-2 licensee, has been permitted to shift his liquor shop from whatever, from BB Road, it's all page 29. Right. BB Road, from BB Road to so and so. Paragraph. Ordinarily, we would have relegated the petitioner to avail of an alternative remedy under section 61 of the Karnataka Excise Act 1965. However, learned counsel for the petitioner submitted that a pure question of law arises for consideration in this petition. They have no. You said it has been contended that shifting of the shop from one taluk to another taluk is not permissible under Rule 23 of Karnataka Excise within bracket General Conditions of Licenses bracket close Rules 1967 paragraph. We thereafter continuation. On the other hand, learned counsel for respondents have submitted that if aforesaid rule is read in its entirety, such a shifting within district is permissible on an order made by the Deputy Commissioner. Paragraph. We have considered the rival submissions made by Rule 23 of the rules read as under quote, right? Thus, it is evident that the Deputy Commissioner is competent to permit shifting of a shop from one location to another within the district. Full stop. Thus, the full stop. The order dated 17/1/2022 has been passed by the Deputy Commissioner in consonance with Rule 23 within bracket 1 of the rules. Full stop. The same therefore does not deserve any interference. In the result, we do not find any merit in these petitions. The same failed and are hereby dismissed.
The prayer being read as before, all the shots will be down.
This is not fair. You told us this is the only legal issue, Rule 23. We have decided it. Don't ask us to come and find out about your antecedents who are you. He is ready with an inquiry. We have not said about him also. Invariably.
I find this application and the petitioner, there is not a request to reconsider the interim order granted by the court. Apparently not, we have not brought the correct facts to the notice of the court.
No, what was the total demand? We were told on that day.
Yeah, that's a mistake.
Oh, how much has?
160 crores was the demand in that case.
What was what is the amount come in this case, Mr. Mahindra?
In this case, it is 70 lakhs, 70.
Out of a total demand, how much you have to pay?
No, all that I'm saying is this, in the earlier
you
occasion,
don't have to pay anything.
no, I have
How
all
much?
is contested.
That's fine. So out of say only modification is amount, right? We have
Yes.
said 1 crore you want modification.
Yeah.
He is not disputing that. So what is the amount instead of 1 crore? Tell us. Cut short.
I would request it to 7 lakhs because what has happened is
14 lakhs. Already pay 14 lakhs. After we expect you to be quick with a one sentence, Nagaran. We can't take that privilege. We have to hear everything, right? We can tell you. Mark the. He is not contesting.
Please.
So therefore, there's nothing to argue.
Please.
Mark the presence. Heard on IA number 2 of 2022. Hearing in full stop. Learned Senior Counsel for the petitioner submits that in similar writ petitions, the similar writ petitions, namely WP number 842/2017 and in WP number 377/2017, the petitioners in the aforesaid writ petitions were asked to pay approximately 7% of the amount of demand. The aforesaid aspect of the matter has not fairly been disputed by learned additional government advocate. Paragraph. The full stop, it is settled in law that there has to be parity even in interim orders, bearing in mind the orders passed in the aforesaid petitions, namely WP number 842/2017 and WP number 377/2017, the ad interim order dated 18/7/2022 is modified, and the petitioner instead of rupees 1 crore is directed to pay a sum of rupees 14 lakhs by way of an ad hoc stamp duty to the aforesaid
Stamp duty and registration fee together.
and registration fee. To the line below, to the aforesaid extent, the interim order dated 18/7/2022 is modified. Accordingly, IA 2 of 22 is disposed. That deposit within 1 week, right? Ad hoc stamp duty and registration charges within 1 week. Yes.
Lord, this petition may be connected with 842, same issues, right?
Yes, sir, for analogous hearing along with
WP 842 of 2017.
842. Yes. 58. 82. '58. Yes, madam.
What notice is complete in this? Serial number 58.
Notice.
The submissions, my lords.
Yes, madam.
My lords, I'm
Notice is not
aggrieved on
ordered.
3 counts, my lords. One, the 4th respondent senior geologist, despite an order of this honorable court, refused to consider my query application, my lord. Second, the 3rd respondent deputy commissioner stands any authority of law vested with
125.
him.
124. Write her name third on the question of admission. Notice on behalf of 124 is accepted by learned additional government advocate. Issue notice to respond number 5. 80. All right, so formally we'll have to issue notice if he accepts, fine. Right. List along with serial number 80. Give that number. Correct. Yes. Yes. Notice has been issued. What happened? Yes. No. What is the show cause notice dated?
The existing clearances in favor of an SC on the constituent category C unions. We are not concerned with
Yes, Mr. Seek instruction. Learned senior counsel for the petitioner heard on the question. Learned senior counsel for the petitioner submits that the impugned show cause notice dated 13/6/2022 has been issued in violation of the para 3.8 of the order passed by Supreme Court in so and so versus so and so 2017 11 SCC 509. Learned additional government advocate praise fund is granted 2 weeks additional issue notice. Learned not issue notice to respond number 2. Learned additional government advocate for 1 and 3 praise fund is granted 3 weeks time to enable him to seek instructions. What Yeah, wait. What we'll hear you. What is it? Which page? 87.
Then this is what is happening.
What happened on 20? Yes. So what happens, like this is under challenge. We have recorded the reason, right? And you cancel the letter of intent on 2nd August. What happens? Huh? Expires. But that's what Supreme Court says, right? When it has just a way, when it has expired. What is Yes.
You should very confident. You should be only. In the traditional sense of that expert, that is to say that even
that question is kept open, right? We have issued notice. We will say that this question is kept open. We are conscious that it's only a show cause notice, but the why we have entertained is that his contention is that it is in contravention of decision of Supreme Court that needs to be examined. That's why you give your submission with regard to this. If you can get back to us by 2nd of August, we will hear before Monday. List on 1st August 2020. Right? Tuesday, 2nd August, right? List on 2nd August. It's the same, right? Same order.
Lord, I appear for the petitioner.
Yes.
Lord, the petitioner is a holder of my lord mining lease granted by the state of Karnataka. The petitioner is also my lord paying the royalty on the same. Now, my lord, the Goods and Service Tax Act and my lord, the notifications issued under imposes GST, treating my lord my.
Yes. You should notice.
Your lordship, in similar matters, I produced that annexure AL, my lord, page 516. This honorable court granted an my lord, this honorable court.
Oh, what 2000? Ah. Ah. Oh. Hey, Mister, it is it pending?
My lord, page number 516, my lord, the division bench of this honorable court, my lord, granted an interim order, my lord, regarding my lord collection of GST on royalty, my lord, page 516, volume number 2, my lord. Similar matters are pending.
Hey, what is it?
Page 516, my lord. Meanwhile, respondents are restrained from demanding and collecting GST or royalty from the petitioner till the next date of hearing.
Are you aware?
Page 516. Identical matters this court has entertained and granted interim order.
516, Mr. Mahendra.
And also, my lord, the previous page, my lord, 514.
One minute.
Last one.
Service tax. Stroke GST on mining lease. See, we'll list it along with this. I'll learned counsel for the petitioner. So why were you trying to argue it of de novo, Mister? First sentence should have been similar petition, page 516.
Please. Yes.
Every time you try to see what is the reaction of the bench, then you will come to 516, right? Is it like that?
No, my lord. In a few words, my lord, I wanted to explain what is the facts of the case instead of, my lord, directly saying.
So when this is the situation, we would advise you to
please. In future, my lord, I will do so.
Right. Counsel for the petitioner submit that rate petition involving similar issue has been entertained and an interim order has been granted. In support of a forces submission, reliance has been placed on an order dated 20th April 2022.
Yes, my lord.
As in WP number 1353/2022 submission, and with a view to maintain parity, it is directed that what order dated, which order?
My lord, there is no order, my lord. Every month, my lord, my lord, under the circulars, we are bound to pay GST.
Therefore, it is directed that the collection and payment of service tax GST on mining lease royalty shall remain state till next date of hearing. List for analogous hearing along with WP number 1593/2022. And 1353. 1353, right?
Yes. My lord, this is 1593 of 2020. 1593.
1593. Clear also.
Grateful.
Yes. Okay, 4:30, that thing has to be called, right? That's 4:30. Yesterday, remind us. Well,
I appear for the
Ah.
petitioner.
Before
For the respondent.
So it's a petition under Article 227 and therefore is what?
Yes.
No, it is under
What
226. Volume
But it is
1,
an
page-
order of the labor court, my lord.
Sir, let Mr. Rao, it's his application, right? Let him contend. He
Yes,
can-
my lord. I
he can
have.
argue anything, right?
Before
Your
my
lordship may kindly see.
starts, I
Your
would like to
lordship may
place
kindly
your
see.
lordship for information.
Your
It should not be said, I did not raise this point in the beginning itself. Therefore, I'm saying this.
All right, so you argue first, then we will hear Mr. Rao later on.
yes, yes.
So I
No,
said,
the
I
question
mean,
is,
we
a
thought
similar
that-
matter,
No.
a similar
what we thought-
question from
All right,
Andhra
Mr.
Pradesh High Court.
Permit him to say, argue your memo and to reply it, then we will hear you.
Let him argue,
right?
my lord, because I don't want to be said that I did not place this before your lordship in the beginning. That's all.
What beginning?
Because a similar question has gone from Andhra Pradesh High Court to the Supreme Court on 22nd of July. Justice Shah and Justice Nagaratna have reserved judgment in the matter. I have produced it. I have asked my learned friend to hand over a copy of this order to you, your lordships. This is the order of the Supreme Court. They reserved judgment in a similar matter. If your lordships want to await it, different
Now
matter.
we have.
Mr. You will have to place on record copy of that petition, whether it was similar. We can't, by this order, we can't ascertain whether it's similar or not. What is this?
Because I read the judgment of Justice B.K. Mishra and Justice Satyanarayana Murthy on the same
This
case.
order, Mr. We don't think that this.
It relates to it. I'll produce the judgment. I'll produce the judgment also.
What judgment? I mean, see.
That is
My
the
lord.
judgment judgment.
My
On
lord.
the appeal.
Mr. The point according to us is simple. His submission is that it's a petition under Article 227, therefore intra-court appeal does not lie. You say it's under Article 226, therefore intra-court appeal lies.
Yes.
That's it, right? So what is
That's right.
What is this? Whether the petition is filed under Article 226 has to be decided with reference to facts of your case and the nature of power, the order which has been passed by Lalit Single Judge. All this has to be read together to record a finding. This can't be decided by Andhra Pradesh High Court and this thing. That will not apply to your case. And we
Very
don't
well,
know-
Miller. Let my learned friend argue. I am prepared to argue the matter.
No, that is how we thought that the issue is. So, but this order, we don't know whether it helps you.
I read the judgment of the Andhra Pradesh High Court.
And we don't know what judgment.
I have read the judgment. I am making a statement from the bar. Justice P.K. Mishra has rendered the judgment.
My lord,
No, Mr. Kasturi.
Milord.
How can we, how your case can be decided with reference to Andhra Pradesh petition?
There, they also discussed the very same question. That's what I'm saying. Your lordship may hear my learned friend. I am prepared to argue.
yes.
We thought by now the argument should have been concluded. That's the problem when senior advocates appear, right?
No.
By now, according to us, the arguments on both sides should have been concluded. When we can't tell you anything, we have to hear you, whatever you say. This all.
Very well, brother. Let my learned friend commence. I'll reply.
Yes, Mr. Rao.
The present writ appeal, my lord, is against a decision of the learned single judge in 41,072 of 2012. The writ petition arose, my lord, for a challenge to the order award of the Labour Court, Additional Labour Court, Bangalore, my lord, dated 23/8/12, in reference number 32 of 98. My lord, now this court, my lord, now has taken a, that is, my lord, view. I have produced, my lord, the latest judgment of this honorable court. That is, my lord, along with my our coordinate bench, my lord. Your lordship may kindly see where my learned friend appeared for the appellant. In WP number 497 of 22, and it is, my lord, your lordship may kindly have a look at that judgment. It has been produced along with the memo, my lord.
When?
Along with the memo.
Along with the memo we have produced.
When have you filed the memo?
Memo, my lord, we have filed it. Your lordship will kindly see.
A memo for dismissal?
Yes.
Yes. Memo for dismissal of the WP.
Along with the appeal.
Writ appeal. Here, my lord, regarding the maintainability of the writ appeal was considered by the lordships. While hearing, page 2, your lordship may kindly see. While hearing the writ appeal, an issue was raised in regard to the issue of maintainability of the writ appeal. However, to understand and appreciate the nature of the proceedings before the Labour Court, it is deemed expedient to state the factual matrix. Then, my lord, that is the appellant union engaged in the manufacture. I think I can skip off, my lord. This is
Para 5.
Yes. It is submitted that the petitioner filed the writ petition.
Para 5.
Para 5. Under writ petition under Article 226 of the Constitution of India, seeking for prayer of certiorari to quash the award dated 5/8/2011, passed by the Labour Court, Bangalore, and that the writ petition is not under Article 227 of the Constitution, and therefore the writ appeal would be maintainable. In support of his contention, he has placed reliance on these decisions. My lord, heard and perused the records. The question that arises for consideration is whether the court appeal, that is, my lord, page 6, your lordship may kindly. 5, I am sorry. Paragraph 5. Whether intra-court appeal under section 5 of the Karnataka High Court Act would be maintainable against an order passed by the learned single judge assailing an award passed by the Labour Court. In order to consider the said issue, it is necessary to consider section 4 of the Karnataka High Court Act. Then, my lord, they have quoted section 4. Then, section 4 of the Act provides for appeals from a judgment, decree, order, or a sentence passed by a single judge in exercise of the original jurisdiction of the High Court. The definition of the original jurisdiction of the Act is not defined. In the absence of definition, we place reliance on Black's Law Dictionary with a view to interpret the phrase original jurisdiction, which is found in section 4 of the Act. As per Black's Law Dictionary, original jurisdiction is jurisdiction in the first instance. Admittedly, the writ petition is filed by the appellant challenging the award order passed by the Labour Court, Bangalore. In catena of decisions, the Honorable Supreme Court culled out the principles governing the difference between the writ of certiorari under Article 226 of the Constitution of India and supervisory jurisdiction under Article 227 of the Constitution of India. It is no longer.
Para 12 is the conclusion, Mr. Rao.
Yes, yes. Ultimately, they said, my lord, a petition will be under 227 only because it's a judicial decision of a court. Because these labor courts are under the supervisory jurisdiction of the High Court. They are, my lord, available. It is a petition under 227 only.
Which paragraph you want to read?
That is even paragraph 11.
Yes.
Yes. The Honorable Apex Court in Kiran v. so and so held, therefore, the petition styled as one under Article 226 would not bar the High Court to exercise the jurisdiction under the Act or under Article 227 of the Constitution. The jurisdiction of the High Court to examine the correctness, legality, and propriety of the determination of any dispute by the tribunals is reserved with the High Court. The nomenclature of the proceedings as a petition under Article 226 of a petition is wholly inconsequential and immaterial. In the instant case, the Labour Court, Bangalore, passed an award in favor of the respondent, which was assailed before the learned single judge, invoking the jurisdiction under Article 227 of the Constitution. The writ petition filed by the petitioner must be held to be one under 227 of the Constitution of India, being a challenge to the judicial order of the Labour Court. Considering the law laid down by the Honorable Supreme Court, Apex Court, and also the facts of the present case, without going into the merits of the appeal, we are thus satisfied that the writ petition being preferred under Article 226 and 220 of the Constitution, challenging the award passed by the Labour Court, the present writ appeal against the order of the learned single judge, which is an intra-court appeal, is not maintainable. And they have relied upon, my lord, two decisions of the Supreme Court, which, my lord, once again relied upon a 9-judge bench decision of the Supreme Court. That is Miraj Kar's judgment, which, my lord, I think I have placed before your lord. Kotidara? Miraj Kar Kotidara. Allah, this decision, that is the decision, my lord, in Radhe Shyam, where they referred to it. It was on a reference. How that? Yes. Your lordship may kindly have a look at that. I have given those authorities. Additional list of authorities.
Yes, yes.
Yes. That is, your lordship may kindly have a look at them. They actually referred to, my lord, a decision of the Supreme Court in paragraph 3. That is, my lord, it was observed, paragraph 3, your lordship may kindly have a look at page 4. As already mentioned, the bench of these two judges who heard the matter was not persuaded to follow the law in Surya Devi Rice case. It was observed the judgment in Surya Devi Rice did not correctly appreciate the ratio in the earlier 9-judge judgment of this court in Naresh Sridhar Mirajkar and others versus State of Maharashtra, wherein this court came to the conclusion certiorari does not lie to quash the judgments of the inferior courts of civil jurisdiction, paragraph 6. With reference to the observations, so and so. Your lordship may kindly see the actually paragraph 18, my lord, at page 28. Of course, it has referred to, my lord, various other decisions because it is on a reference, my lord. This case came before a bench of 2 judges, because the earlier view in Suryadev's case, my lord, was held to be not correct.
Page 22 also we can refer. Page 22 also we can refer.
They have referred to Halsbury and all that, my lord. I do not want to trouble your lordship with all that. Paragraph 15, your lordship may kindly have a look at page 26. Paragraph 15. It's a long judgment. I'll only. While the above judgments dealt with the question whether judicial order could violate a fundamental, it was clearly laid down the challenge to judicial orders would lie by way of an appeal or revision or under Article 227 and not by way of a writ under Article 226 or 32. Then, my lord, now your lordship may kindly turn to paragraph 18 at page 28. Thus, my lord, they have quoted a judgment. Thus, it has been clearly laid down by this court that the order of the civil court could be challenged under Article 227 and 226, and not under Article 226. We may now come to the judgment of Suryadev Rai. Therein, the appellant was aggrieved by a denial of interim injunction in a pending suit and preferred a writ petition in the High Court stating that the CPC amendment, Article of 46 of 99, remedy of revision under Article Section 115 was no longer available. The High Court dismissed the petition following its full bench view in Gangasaran to the effect that writ was not maintainable. As no mandamus could issue against a private person, the bench considered the question of impact of CPC amendment or power on power and jurisdiction in the High Court to entertain a writ petition under Article 226 or a petition under Article 227 of the Constitution. The bench noted the legal position after CPC amendment, revisional jurisdiction of the High Court, and against interlocutory orders curtailed. The bench then referred to the history of the writ of certiorari. Then, my lord, after that, paragraph 24, your lordship may at the bottom. The difference between Article 226 and 227 of the Constitution was well brought out in the Umaraji case of Maharashtra versus Radhabai so-and-so proceedings under Article 226 are in exercise of the original jurisdiction of the High Court, while proceedings under Article 227 of the Constitution are not original, but only supervisory. Under Article 227 substantially reproduces the provisions of Section 107 of the Government of India Act, accepting that the power of India superintendence has been extended by this article to tribunals as well, though the power is akin to that of ordinary court of appeal, yet the power under Article 227 is intended to be used sparingly and only in appropriate cases for the purpose of keeping the subordinate courts and tribunals within the bounds of their authority and not correcting mere errors. The authority and not for, the power may be exercised in cases occasioning grave injustice or failure of justice in such when the court or tribunal has assumed a jurisdiction which does not have, has failed to exercise a jurisdiction which it does have, and failure of occasioning or a failure of justice. The jurisdiction, though available, is being exercised in a matter which is tantamount to so and so. Then, my lord, paragraph 20, page 31, my lord. So it is the above holding correctness of which was doubted in the referring order already mentioned above. That is why, my lord, the matter came before the court on a reference. This is paragraph 21. It is true that the courts has laid down that the technicalities associated with the prerogative writs in the England have no role to play under our constitutional scheme. That is so and so. My lord, I will not trouble your lordship. Ultimately, the court said, my lord, the view taken at paragraph 22. Your lordship may kindly turn to paragraph 22 and page 32. The bench in Suryadev Rai also observed in paragraph 21 of its judgment the distinction between articles 226 and 227 stood almost obliterated. In paragraph 21 of the said judgment, distinction in the two articles has been noted. In view thereof, the observation that scope of article 226 and 227 was obliterated was not correct, as rightly observed by referring bench at paragraph 32 quoted above. We make it clear that though despite the curtailment of the revisional jurisdiction under section 115 of the Civil Procedure Code, jurisdiction of the High Court under article 227 remains unaffected. It has been wrongly assumed in certain quarters that the said jurisdiction has been expanded. Scope of article 227 has been explained in several decisions, so and so, my lord. Then paragraph 23 at page 34. Thus, we are of the view that judicial orders of the civil courts, this is important, my lord. Paragraph 23. Thus, we are of the view that judicial orders of the civil courts are not amenable to a writ of certiorari under article 226. We are also in agreement with the view of the referring bench that a writ of mandamus does not lie against a private person not discharging his public duty under scope of so and so. Then, my lord, this is what, my lord, they have said. After referring to all this, they said that Suryadev's case is wrongly decided, my lord, in paragraph 24. It's a short para, I will just read to your lordship. We may now deal with the submission made on behalf of the respondent that in view of the Suryadev stands approved by a larger bench so and so, and that ground correctness of that said view cannot be gone into so and so. In Shale, though reference has been made to Suryadev, the same is only for the purpose of scope of the power under 227. There is no discussion on the issue of the maintainability of the petition under article 226. In Mahendra so and so, your lordship can skip off. Now, accordingly, paragraph 25, we answer the question referred to us as follows. Judicial orders of the civil court are not amenable to the writ jurisdiction under article 226 of the Constitution. Jurisdiction under article 227 is distinct from the jurisdiction under article 226. Then in the matter so and so. Then, my lord, matter was referred to the, that is, this is a 3-judge bench, my lord. Then it is referred to a larger bench. Now, my lord, there is also a latest judgment of the Supreme Court, which I have produced, my lord. That is at page 37. And your lordship, 17, 18, 19, 20. Para 17, my lord. They have also taken the same view. para 17. 17. I'll, you can take it. This was a case of a work board's jurisdiction, my lord, and a section came. Then they referred to Chandra Kumar's case, that is a 97-3 Supreme Court 261 versus Union of India. Thereafter, at page 8, paragraph 19, at page 50, they refer to, my lord, the earlier judgment of 3 judges. A 3 judgment in a judgment in Radhesham, they have referred, my lord, and have held the observations in paragraph 25 of the judgment in Suryadev Rai to be held not good law. Suryadev, it was held that the order of the civil court could be challenged by a petitioner in Article 226, so and so. Then, my lord, they quote from that. Then paragraph 20. Therefore, when a petition is filed against an order of the tribunal before the High Court exercises the jurisdiction under Article 227 of the Constitution of India. Paragraph 20, my lord, at page 51. Your Lordship may kindly see paragraph 20. Therefore, it is wholly immaterial that the petition was titled as a writ petition. It may be noticed that in certain high courts, petition under Article 227 is titled as a writ petition, in certain other high courts as revision petition, and in certain others as a miscellaneous petition. However, keeping in view the nature of the order passed, more particularly in the right of the proviso to subsection 8 of section 83 of the Act, the High Court exercised the jurisdiction only under the Act. The jurisdiction of the High Court is restricted to only to examine the correctness, legality, or propriety of the findings recorded by the Works Tribunal. The High Court exercises the jurisdiction conferred proviso to 9 so and so. We find no merit. So and so. That is Your Lordship may kindly see at paragraph 53. Page 53. Page 53, my lord. It's a quotation. Yes. Yes. Nomenclature. Your Lordship may kindly see lawyers. Of course.
That is Pepsi Foods, Mr. Rao. The proposition is para 23. 23.
Yes. Yes. Paragraph 23. The petition styled as one under Article 26 would not bar the High Court to exercise the jurisdiction under the Act or under Article 220 of the Constitution. The jurisdiction of the High Court to examine the correctness, legality, and propriety or determination of any dispute by the tribunal is reserved with the High Court. The nomenclature of the proceedings as a petition under 226 or a petition under 226 is wholly inconsequential and immaterial. That's all, my lord, I have. My lord, the courts have, Supreme Court has said. So, and a coordinate bench, my lord, has taken a view that these writ petitions are not maintainable when it is against a decision of a court, which is under the supervisory jurisdiction of this court. Yes.
Yes, Mr. Kasturi. Yes, please.
Kasturi sir, you are muted, sir.
Sorry, Manoj. Para 10 of
Mr.
the
Rao had muted you. Huh?
dumbfounded.
Right,
He has made me dumbfounded, Manoj.
Yes, yes. Yes, please.
Your Lordship may kindly have a look at para 10 of the judgment of the coordinate bench my learned friend was referring to.
Yes.
The Honorable Habeas Court in the Caparo Engineering Limited, India Limited, Umed Singh, Lodi, and another, etc., in para point 7.9, stated as follows. Now, as far as submission on behalf of the appellant that the learned single High Court wrongly treated the petitions under 227, and as such, the learned single judge ought to have treated the petition under 226. Therefore, the writ appeal before the learned single judge have been maintainable is concerned. At the outset, it is required to be noted that before the learned single judge, in the cause of the title, especially Article 226 has been mentioned. Even in prayer clause, no writ of certiorari is sought. The prayer is simply to quash and set aside the judgment of the award of the passed by the Labour Court, and therefore, in fact situation, the division bench has rightly dismissed the writ appeal as not maintainable. Be that as it may, even for the sake of submission, assuming that the accepted submission of petition before the learned single judge ought to have treated the under Article 226, the writ appeal would have been maintainable in the facts and circumstances of the case. Instead of remanding the matter, etc., they go on to decide the matter on merits. Now, kindly see, my lord, his lordship refers to this at para 11. The apex court in Kiran Devi versus Bihar is so and so held that therefore the petition styled as 100 would not bar the High Court to exercise jurisdiction under the Act under one Constitution. The jurisdiction of the High Court to examine the correctness, legality, propriety, determination of any dispute by the tribunal is reserved to the High Court. The nomenclature of proceeding is the petition under 226 or 227 is only inconsequential, immaterial. Now, your lordship will kindly see. Article 226 starts with the power of the High Court issue writs in the nature of mandamus, certiorari, etc., 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 prohibition, and all these things. Whereas 227 starts with power of the High Court to superintendent power of the High Court. There are two different aspects of the matter. Now, your lordship may kindly see the next paragraph, paragraph 12. In the instance case, the Labour Court Bangalore passed an award in favor of the respondent, which was assigned before the learned single judge, invoking the jurisdiction of 220. It's a factual mistake. Kindly see page 96 of volume 1 of my paper book. I have invoked the original jurisdiction of the High Court under Article 226 of the Constitution. And I have asked for a certiorari. I have not asked for a 227 jurisdiction who superintendents over the lower courts. In fact, I would submit the Labour Court is not an inferior court. As my learned friend read to your lordship, the Waqf Board case, where the power was given to the High Court to interfere with the order of the Waqf Board. That is entirely different. The statutory power is given to the High Court as a then it becomes a lower court, like the Workmen's Compensation Court, as provided in the Workmen's Compensation Act, Section 30, Section 92 of the ESI Act. The power is given to the High Court, then they become subordinate courts. Here, the award is final and it is not appealable. Therefore, I can invoke only 226. In that petition in Capera Engineering, which is followed by the Honorable Division Bench, presided by the Chief Justice, the then Chief Justice, the case was one under filed only under 227. They wanted the High Court, they said the High Court should have treated it as 226. The Supreme Court said no. Kindly refer to the Capera judgment at para 5.8. The Capera judgment is produced before your lordships. Para 3, your lordship may kindly notice only these three paragraphs: 3.6, 5.8, and 7.9. That is Justice Shah's judgment. Now, my lord, the 5-judge bench of this court in ILR 2005 Karnataka 2503 have clearly held the intra-court appeal under Article Section 4 is maintainable
ಮಹಾರಾಷ್ಟ್ರ ಕೇಸ್ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ.
Kindly see, this is a judgment of 5 judges of our court. At internal page 2520.
ILR is quoting.
ILR judgment, my lord.
He is referring to some other ILR.
5 judges.
5 judges.
Yes. That is, my lord, Gurushan Patedar case. Kindly come to page 2520. After noticing the observations of Robert Vigram case, their lordships come to this. Going by the language used in section 4, which has been introduced in the earlier part of the judgment, reproduced in the earlier part of the judgment, we have no doubt in our mind that an appeal has been provided against an order by single judge only when it is passed in exercise of jurisdiction, original jurisdiction, that is, when he deals with a writ petition under clause 1 of Article 226 of the Constitution. The right of appeal is already observed is a statutory right, and where the statute is provided for an appeal only against the order of a single judge passed in excess of original jurisdiction, it has to be held that no appeal would lie against the order passed by him in excess of supervisory jurisdiction under Article 227. They distinguish supervisory and statutory jurisdiction. Neither the rules nor the form prescribed by the High Court could override control the provisions of section 4 of the Act, which provides for intra-court appeal only against orders passed in excess of original jurisdiction. Moreover, rules 2 and 226 of the writ proceeding do not provide for an appeal against an order of Leonard signature passed in excess of supervisory jurisdiction. In this view of the matter, we are of the opinion that the law laid down by the division of this court in Kalpana Theatre's case was the correct law, and the full bench was not right in overruling the same. We have therefore no hesitation in holding that the law laid down by the full bench theatre case, hotels case,
what is arguing, Mr. that a petition under Article 227 does not lie. That's what the full benches of 5 judge benches also said.
Yes. Therefore, my lord, my petition was invoking the original jurisdiction of the High Court under Article 226.
So you tell us that it is permissible for you to invoke 226 in case an order is passed by the Labour Court.
Because there is no appeal provided, like the Buckford case my learned friend read to your lordship. No appeal is provided against the award of a Labour Court. It is final. Only they can be quashed by a High Court under Article 226 of the Constitution. Unlike the orders passed by civil courts. That's what Radhesham case, my learned friend, kindly see the last portion of the judgment. Radhesham, para 29. Accordingly, we answer the question referred to us as follows. Judicial orders of the civil court are not amenable to writ jurisdiction under Article 226. Jurisdiction of 226 is distinct from jurisdiction under Article 227 and 226. They are distinct. Subordinate courts, 115, the appeal will petition will be maintained to 227 to correct an error apparent in a superintendent's jurisdiction. 226 is purely a certiorari proceeding, where an error of law apparent at the face of record is brought to the notice of the High Court. My petition was invoking original jurisdiction under Article 226. The two articles read differently. It does not, 226 does not say superintendent's power, unlike 482 of the CRPC. It specifically says power to issue writs in the nature of certiorari, mandamus, prohibition, habeas corpus, etc. Therefore, my lord, having regard to the judgment cited by Leonard from Mr. Radhesham's case, in Radhesham's case, I would submit a petition under 226 alone will lie against the order of a tribunal because it is not a subordinate court in terms of section 115 of the CPC or the definition of a subordinate court, civil court under the Civil Courts Act. Though the powers of taking evidence and other things have been given to the labor court or the tribunal. The Supreme Court said it has all the trappings of a court, but not a court. In Bharat Bank, 1958, 1950 Supreme Court, and 1959, 2 LLJ, page 249, Union of India, Ms. Verma. In fact, the 7 judges of this court in my Lord, the 7 judges' judgment of this court has
It is Supreme Court. Which para? Para? Yes.
The question was, in that case, was whether the court of review, which was set up in 1935 under Commonwealth Income Tax, the court exercising judicial powers of the Commonwealth, the High Court of Australia decided by majority that it was an administrative and not a judicial tribunal. The majority judgment was approved by Privy Council, 19th March, in post judgment that it decided cases show that tribunals which possess many of the practices of court, but which nevertheless are not stored in the strict sense.
What do you say? Labor court is not a court.
Labor court is civil court.
Ah. Under which enactment the power, the order has been passed by the labor court? Yeah, but what happened to Mr. Kasturi? He gone away.
Milord, may I come personally and argue tomorrow, Milord?
Huh?
There has been some interruption.
Please go ahead. Now we are able to hear you.
Very well, Milord. Milord, 7 judges of our court in area 2009 Karnataka 119. In Tamanna's case, the questions referred to them are answered at page
'Hey, this is Mr. It does not need any case law to say that an appeal against an order passed under Article 227 does not lie. This is what it has been held. Who is saying that?
Kindly have a look at conclusion. Conclusion, Milord. Paragraph. The page number.
That is what Mr. Rao is arguing, that it's 227 appeal does not lie.
Correct.
227,
I agree with my learned friend. I cannot file an appeal. 226, my submission is
about this proposition.
Milord. Sorry, Milord.
To tell us that labor court is not a court subordinate to the High Court, number 1, and therefore a petition can be filed under Article 226.
26 only. It does not come under this. Your Lordship, kindly see the conclusions.
We are sure that this is the question which is not arising before this court for the first time in 75 years of the history. Yes.
Even Kalpana Theatre also, my lord, kindly have a look at my learned friend has produced. That is, my lord, para 6, 8 and 12. Your lordship will kindly notice. Kalpana Theatre, my learned friend is relying on that in his memo. I would request your lordships to have a look at para 6, 8 and 12.
I have not said the Kalpana Theatre.
Kalpana Theatre has been upheld, while Ritz Hotel has been overruled. Para 2, applying the test indicated in decisions of the Supreme Court referred above, it will have to be held that all these cases appellants invoke supervisory jurisdiction of the High Court. Therefore, writ appeal will not lie. I am invoking the original jurisdiction of the High Court.
No, nobody is arguing that against an order passed under Article 227 an appeal lies. No, it is nobody's case.
What my learned friend is saying, civil labor court is a subordinate court of the High Court. It is not so.
So this is.
It may be inferior tribunal to the High Court, but it is not a subordinate court, is my respectful submission.
Which judgment, which paragraph you are relying? 95? What? Mr. What? Which paragraph? No, don't read. Tell us what paragraph.
Well, may make one submission.
I will see. We will appreciate if I mean, you tell us the proposition for which you are relying. Just referring to para 5 to 12 doesn't make head note. Head note is something different. There is no dispute that against an order passed under Article 227, writ appeal does not lie. We are not holding that it lies.
Miller, may I make one more submission? Another coordinate bench of this court has, in sitting Gulbarga bench, has taken a similar different view than the view taken by the Honorable Chief Justice.
What is it, para 5? Gujarat CH-2. Fine, let him be there. We just asked you the paragraph. So you are relying on para 5 of this 95. What is it? Yes, Mr. Kasturi.
Miller, in para 8 also, in Kalpana Theatre's case, management of Kalpana Theatre, if the petition is one filed under Article 226 of the
Mr.
Constitution.
Kasturi, you have both of you and Mr. Rao, both of you conveniently forgot that we told you that we will give you 20 minutes together. Mr. Rao has taken more than 20 minutes. Your 20 minutes are also over.
Please don't restrain. It's a very important question. I will accept a large number of cases before your lordships. Kindly grant us that indulgence. I beseech you. Please.
No, we are not in a hurry. In the lighter vein, Mr. At 4:25, we can tell you.
No, my lord, it's not like that.
No, we will give you every day 4:30. We will hear 15 minutes every day till you can.
No. Tomorrow, you kindly give me 15, 20 minutes. Tomorrow morning, I'll finish it off.
No, not morning. This is why it should be given precedence over every other case.
No, kindly. Then, Lord, I'll finish up today.
We are hearing you. Please go ahead.
I'll complete. Then I'll complete. I thought your lordship has got another case at 4:30. Anyway, that's it. Para 16, Kalpana Theatre. Para 8 and my lord. Para 12 for the judgment. It is a supervisory jurisdiction. If I invoke, I cannot file a writ appeal. If I invoke a sessionary jurisdiction, which is the original jurisdiction of the High Court, I also fall under para 29 of Radheshyam. I come within the purview of that observation. Then, my lord, Patedar is affirmed by 7 judges of this court.
What affirmed?
Gurshant Patedar's case, 5 judges, is approved.
But you want 2
Their
judges.
lordships, my lord, there are 12.2. In 7 judges case, Tamanna's case, the answer is as follows. After they answer the question, yeah. The second question referred to the larger bench by order in Saraswati batch, so and so. In view of the amendment of sections 9 and 10 of the Karnataka Court Act, whether an intra-court appeal under section 4 of the Act is maintainable on the order passed by a single judge in exercise of power conferred at 227 or 226 or and 227 of the Constitution of India, that is answered as follows: that an intra-court appeal is not maintainable under section 4 of the Karnataka High Court Act against order passed by a single judge in exercise of Article 226 in the matter arising under my order made in deciding an issue passed by a court subordinate to the High Court. That is the answer given by the 7 judges. And Patedar case does not require any reconsideration. Similarly, my lord, a coordinate bench of this court.
5 judges. I will they said against 227.
No appeal lies. Nobody is saying that it lies. I don't know what is. No, we are. Please understand, Mr. We are not holding that against an order under Article 227 and appeal lies. This is nobody's case. Yes, you are citing decisions on this issue. Nobody is holding that against an order passed under Article 227. Appeal does not lie.
My submission is this, Lord.
That's
Labor
what
court
Rao is arguing. That's what you are citing in its favor.
Lord, the labor court is not a subordinate court. He is my respectful submission to your lordships.
Just a minute, let him conclude. He is arguing.
Therefore, it is not brought under 115 of the CPC. Though only the orders awards of the labor courts are final and can only be challenged in a petition under Article 226. Because the Supreme Court said the award can be, while upholding the provisions of Section 11A, the Supreme Court in Christian Medical College said that the order of the award of the labor court.
Which medical college, Mr.? We are not that well versed as you are. Which medical college?
1988 Supreme Court, my lord. 1988.
You have to tell us. I mean, otherwise, what we don't get it.
My lord, I'll put you the copy. I'll put you the copy of that. I'm sorry I was not able to come to court because of some physical disability. I will certainly, if your lordship grants me that intelligence, will come and address your lordship tomorrow. But the 88 Supreme Court, the Supreme Court.
Which page? 88 Supreme Court, which page, Mr.
1988 1LJ, page 262, my lord. Christian Medical College, 1988 1LJ, page 262. Their lordships have held the award of the labor code is subject to judicial review by the High Court under Article 226. Therefore, since the award is a final, not to subject appeal, I can invoke only the jurisdiction of 226. Because it is not a subordinate tribunal, it is my submission to your lordships.
Yep.
My lord, a coordinate bench of this court, Gulbarga bench, my lord, presided by
again, it's a division bench. What is it? Gulbarga
same bench. Lord, they have rejected the contention raised by the management in that case that the appeal cannot lie by workman cannot file an appeal against the order of the single judge. That is Justice Fanindra and Justice another honorable judge. the Lordships has rejected the contention of the counsel for the management that writ appeal does not right.
Which paragraph?
1 second, Lord. I lost the paper here. Gulberg are using my judgment. 1 second.
430.
My Lord, I'm sorry. This is similar dated 13th July 2022 in writ appeal number 2001022. The paragraph.
Oh, no, the judgment provided to us is in writ appeal number 100215 of 2017, disposed of on 26 February 2020. You are referring to some other judgment.
Yes, my Lord. Another division in judgment of this
Dharwad
court.
bench.
No, this is Kalburgi.
Hey,
Kalburgi
Mr.
judgment.
You know, he is referring to Kalburgi. You give us Dharwad. Why?
This
You are
is
not
Milord-
relying on this Dharwad bench, right?
No, my Lord.
Yes,
This
you are
is
not
Milord,
relying.
the Kalburgi bench on 13th July
So give it to
2022.
him. Give it back to him. All right, we will hear you tomorrow. Whenever
Much obliged.
this for further hearing.
I'm sorry, my Lord, because I could not get it by the copy immediately.
On that 430. Not 430. Whenever it comes, we don't know. We don't know when it will be called. If tomorrow it is listed. What time, perhaps we cannot tell you. What for me? He is arguing, right? You are also arguing. No, this not this. Choose between the two. Either you will continue. He has commenced here. No. This thing we have held, Mr. We are bound by our judgment. We have written 10 pages to write that appellant cannot engage two counsels, and we cannot argue. We don't know. This is not a public interest litigation. All the case. Oh, Mr. You are, we'll continue tomorrow. Monday. Which case? Which case? 46, right? Monday, madam. 52, Monday. Yes, on Monday. Yes. That other case called for 14%. Person, all that. I told you. Yes.
People come to know.
Yes. Huh?
You see, there is image. It is clear. Fully justified in holding that the bringing order to the officer who knows the results are not being supported by any individual. Of course, the exception of the three for the effect on 15 months, that according to the meeting number, we will have you are feeling like it was that would have been before the entry of the age to the point. This limited food and all including that the ability of just to be equal to the order. Whether there is 50 miles or urban city, they will push you forward. Now, in fact, labor court is not empowered to reapply the evidence in this proceeding. Labor court has to see whether there is other city in the way, but in this case, evidence is being persuaded by creating Whether the knowledge about results of the field to the case of it is very complicated. It is really that the respondent is in a position to understand that it is a without proper and valid reason. It is very complicated. In which cases of record indicate that the respondent association does not take any effort to know whether it is valid or not. A case in chemical abuse it is clear that the respondent wants to leave in order to take some steps against state society who hinders it in able. So there is a mention in the as to result of mosquito biting. If at the index is not the rate cases so that the serious allegations are raised against the influence are completely proven. Not only such reasons cannot be considered as sufficient reason and it is pertaining to law. There are people to deal with this. Solid on this, even at the time of any case in this field. Because and in the lower state, there is no good reason actually leading to this. In the beginning, it clearly stated you are remaining out without making you without submitting to your at that time, so that they brought these two documents are after that, the man keeping his special he responsible to take leave of 80 I cannot tell you the same day. I was transferred from Bangalore. I was brought even the I must come to Bangalore for my wife doing different side Bangalore. Next day, to the activity. Exhibit young people. Clearly showing that leave application or reached on 28/2005. That is 2 days. But that leave application was sent to the exam by the depot manager on 24/2005 for 4 days. 25 next day. Slowly, the completion 7 days. And was the day before Why they have not intimation of rejecting the debate, they have not sent. If anything, law has not constitutionally. And responded. Telegram on the grant of new training management are also the writings of the labor. Now, it is India's training is not for time. They are not producing any decision order. They are not communicating to me. All these 11 days, those days, the email and video. I do not know. Should I have been a very personally whether my video is not there, I will see. Again. Yeah, you. It was wrong. Yes. Yes. I was opportunity to compare some produce both of good care. By demanding back. You're also direct labor. Only consider dharma, meaning single pages and also the observe that these two documents are published by management. Your employers if employee or I would be mad. Yes, sir. But then, and then case was but then later to ask another detail of that. So that is yes, you are given feedback. So the matter was not reached a finality. It is ending. You will discover even if anything was related to God, still questioning these two documents. So I find that before the to find the official filing knowledge, it doesn't document. Then whether you provide to produce those or okay. Those documents are not by you. Indeed, I would have be able to but they are not produced in the anyway. That is the problem now. Arrived. I was lost order. And it is order. They have appeared. Why those documents are not produced before the or the reason not produced. So I find they can be before you. But the able to not there. I find now I have if those two original documents are placed before this non-verbal code it was this case within 15 minutes because on those two documents complaint some write me some notice will be there in original somebody has even arrest is code
Here you find it that day 40 minutes, now 20 minutes, 1 hour has gone. If you want to continue further, we will hear you. Tomorrow. Tomorrow. 15% heard. He commenced his, 14% commenced his submission. However, on account of paucity of time, same could not be concluded. This for further hearing tomorrow at 4:30. We continue like that.
Your Lordship, may I make a mention? Your Lordships, may I make a mention, Your Lordship?
You want to argue some case, right?
No, Your Lordship.
Which case? Which case?
Your Lordship, the matter.
Don't. Too many cases are coming up tomorrow. There is no urgency at 5 o'clock to seek an adjournment, right?
No, Your Lordship, serial number 69, there is some urgency. I had moved that matter. So the matter may kindly be listed tomorrow. It's just my
All, that's what we are telling you. All
Obliged.
cases will be repeated tomorrow.
Obliged.
Whatever cases are not reached will come up tomorrow. It is 62 cases today.
Date given matters are there. That were they were also inserted. That's why.
Tomorrow. Mr. Mahendra, yes. Case 66. Right. Learned counsel for the petitioner prayed for a judgment to enable him to prepare the case and argue the case after 2 weeks. So that's why after 2 weeks. Right.
Court officer?
Court officer. Sir. Court officer.
Sir.
Serial number 63, repeat.
Sir, serial number 62.
Ella, repeat, sir.
And 62, sir, 62.
Ella repeat, sir.
Sir, 79 matter was taken up.
Repeat.